Saw a fox in the courthouse steps, twisting and turning without regrets, with downward dogs and feline ploys, distracting me from ecosystem joys. No more yoga under legal skies. No more poses that mystify. Keep your namaste far away. I'm here to win, not watch you sway. Position she bends, a warrior pose that never ends. I plead the case with weary eyes. She shifts the tree and I lose the prize. Sway. In the glow of YouTube, she salutes the sun. But courtrooms shouldn't be a place for fun. Clarity lost in her serene haze. My objections echo in a daze. Stay far away. I'm here to win, not watch you sway.
Welcome back, everybody. I hope that you are surviving the heat wave that has hit the East Coast, at least. I don't know if it's as hot as it is here where you are, Tug, but we are dealing with temperatures that are in the high 90s, low 100s.
Oh, yes.
It's rough.
Hot and it is muggy. So,
yes. Hot and muggy. But that's what summer is supposed to be. And I, for one, am glad summer is here. I really enjoyed my weekend. I hope you all enjoyed your weekend and touched some grass and spent time with family. That's what I did. I spent the entire weekend with my honey under our new umbrella on our porch, grilling out, doing yard work, just hanging out together, having a lot of fun. Water balloons with the kids, spraying the dog with water. It was just a ton of fun. I just loved it, every minute of it. Did you have a good weekend, Tug?
I did. I was lazy, watched movies Sunday. That's pretty much all I did Sunday. And Saturday I took the kids out and ran around with them a bit, so it was pretty good.
Yeah, I like the weekend, boy. I don't know how you work through it sometimes. I swear, you're amazing. You're like a machine.
I would work every freaking day if the kids didn't force me not to. I would have worked Sunday too, but they're like, no, we must sit down and do stuff. I was like, okay, well, we'll have more time to, so good.
Well, it's good to take some time off, though. It really is. It's good to take time off and hang out with the kids and do other things. I really enjoyed not knowing any of the craziness that was going on in this case all weekend long. I pretty much have no knowledge of anything that happened. If you want to support the show, by the way, make sure that you hit that like button which is a thumbs up on both YouTube and Rumble. Hello, Rumble Ghetto. I see you over there. Thanks for being here. Make sure you hit that thumbs up and subscribe on whichever channel you're on. Make sure you hit the subscribe button. And of course, if you like the content and you want to make the haters roll around in a frothing rage on the floor like vampires, very fat ones who got hit with holy water, make sure you send super chats or super tips, which is the new fun way to use AI for satire and parody to have your words read to me in silly voices created by a computer. That is so fun. It's pinned to the top of the chat, by the way. If you want to go to supertip.gg/Megan Fox, you can test out the AI voices. And if you're wondering, well, what the heck do those sound like? We have a few already, so I might as well play one. Ryan Poole, thanks for the $9.50.
Mrs. Fox, is it true that you received information about an opposing lawyer and didn't share with the court?
Just because I sent a super tip doesn't make me a stalker.
Go on, Megan. Tell them. They're dying to know.
Oh, no. You will not make me tell you the ridiculous and outrageous things Nick Rekieta says to me on chat in texts.
Oh, is that what that's the fish for? I saw the post about, the vague post. I saw
the vague posting. Yes. I refuse to do it. Nick sometimes doesn't have good self-control, and I will be his self-control for him. Period. Some things are better left unsaid.
That is the understatement of the millennium right there. Not good self-control.
I'm going to help him. I'm going to help him have self-control and not say things he shouldn't say or use my chat to do it. All right. Anyway, Muppet Man Dwayne Rapp, thanks for the 1242.
Hey, Megan Fox, put that J-hip person on here, please.
Yeah, Megan, we need another potato dog on here.
Hello, my name is Mike.
Megan, you don't need that J-hip, but sarcasm, she the best.
Hey, Megan Fox, put that J-hip person
I guess I hit it
here,
twice
please.
again. There we go.
Oh, yeah, that might be a good time. So I've decided after much thought that I do need a lawyer. So Wednesday, my lawyer, J-Hip, will be making our first statement on his show. That's correct.
Excellent. Excellent. Yes, I heard you come up with that idea. That J-Hip should be your attorney. And I don't know if I'm going to sign up for that. I don't know. Maybe I'll wait for his first statement. But I'm interested. I'll put it that way.
Yeah, so am I. I'm not going to listen to it beforehand. He's my attorney. I guess I'll listen to it while it happens.
Yeah, live. Just sure. Great idea. That's a terrific idea.
It's no worse strategy, right?
It's no worse than what the ecosystem has decided to do.
God, legally. I read through the 2L1 filing the other night. Oh my God. It is so bad. It was worse than I thought it could be. It really was. I couldn't tell where certain things began and ended. You remember the judge saying, I'm not supposed to be the finder of fact. You're supposed to tell me where everything is. Well, it was just all blathering. There wasn't actually any fact to find in it.
Yeah, you're talking about Fleece's one?
Mm-hmm. Yeah.
Mm-hmm. Yeah, it was really strange to me because it didn't do anything for her. It was all about Ray. So I don't understand. I don't think it did what she thought it did. Because, Ray doesn't have anything to do with her. She's been served separately. Whether Ray is in the case or not in the case has no effect on her. She's been served. She's in. So she needs to argue for herself, not for Ray. And I don't know what that accomplished.
Well, arguing on behalf of someone else while screaming that he has nothing to do with this, it's kind of a bizarre strategy, But it was made even worse by the fact that, when she would argue something, you wouldn't know where like certain things began or ended. Like she was quoting she was quoting Lips, for example, right? And she went from just having normal paragraphs to numbering. Okay, well, the numbering doesn't stop when she brings it in. She continues going through, like Lips, it'll be like, here's what she said in her lawsuit, 1, 2, 3. Then the numbers just keep continuing, and it goes into Ray, and you're like, wait a minute. Did she say something about Ray? Is that part of it too?
It's very bizarre. I don't understand the strategy there. I don't. But then again,
strategy.
I don't know. I don't know. I don't know what to say about that. I really don't. Those of you who are watching, I just turned the banner on because some of you were asking for the Cash App and the Venmo as well. You can, if you're into those, instead of super chats or super tips, you can do that as well. I found something today though that I'm very interested in. I didn't realize, and I know that you knew this, and I think with so much happening, right? So much happened all at once that I think I forgot about the dropping of counts 2 and 3 from the counterclaim, from Lynette and John's counterclaim in the Fed case. I forgot about it. I completely spaced on it. So when they filed recently to drop claim 1, I believed 2 and 3 were still live, but they're not. So they dropped the entire counterclaim. I just want to make that very clear. I did not realize that until today when I was going over what I wanted to read tonight. I was like, hold on a minute. They dropped 2 and 3 too? And they did.
Yep.
So the entire counterclaim, and I found a legal checkmate for Jeremy Hales here. I have found it. I believe that he has won his case, and there's no way forward for Lynette or Bruce or anybody now because of what they've done. And I'm going to explain that. But did you see my thumbnail today, Tug?
No.
Okay, I have to bring it up because it is hilarious. It is so freaking funny. I worked very hard on this, but I was thinking about checkmate in chess, and I asked ChatGPT to do this for me, and it did just a great job, an absolutely great job on it. Okay, here it is. Let me pull this up. God, this is funny. So I think that they have not noticed. I don't think Bruce has noticed that he's in this position, that it's checkmate. Check out this.
That's hilarious.
Look at the Indians logo on the chess piece.
Oh my God, that's pretty funny.
I know. I love my thumbnail. I think this thumbnail is so good. It's one of my favorites. And, but yeah, there's something that has happened. And it gets complicated because it's about federal procedure, rules of procedure. But I did a lot of studying today on rules of procedure and where I think that they went wrong. And it's really something. So let me pull up what I have here. So if we go back, let's go back real quick to March 23rd. I believe it was the 23rd. Hold on, let me look. It is, how do I make this bigger? How do I embiggen? Here we go. Yeah, March 23rd. We have, let me share this page or window or whatever the hell. Here we go. Share. March 23rd. Can you guys see this? No, I have to add it to the stage. That would be helpful, Megan.
Yeah, that's really helpful.
To add it to the stage. Okay. So we had on March 23rd, the defendant's request. So this is Jeremy Hales versus LMNOP and John Cook. The defendant's request for order under FRCP 41A2 dismissing counterclaim counts 2 and 3. This is what I missed. I know we reported it when it happened, but it didn't stick in my brain. It just didn't. So here they
so
dismissed.
Much, you know?
I know, right? They dismissed 2 and 3, which was the copyright claim and the invasion of privacy claim. And it says here that the rule 41A2 provides, except as provided in rule 41A1, an action may be dismissed at the plaintiff's request only by court order on terms that the court considers proper, unless the order states otherwise. Dismissal under this paragraph is without prejudice. The defendants, now this part is very important. The defendants wish to pursue these claims in a separate action in their forum of choice, along with other claims against the plaintiff unrelated to this case. Dismissal will also render moot the motions to dismiss, okay, eliminating the need for those. And then look at footnote number 1. Those motions are not wasted because they can be used by the plaintiff in response to the same claims when brought in a different action. So here they are saying, we filed this counterclaim, but we're dismissing it now because we want to file it at a different time somewhere else, right? That's how you understand this.
Yeah.
Okay. Yeah, this is not allowed. They already filed this and dismissed it in state court. And what does that mean? Well, I'll tell you. It means that they're going to run up against the two dismissal rule. There is a rule. And now Randy, in his filing, let's see, it would be the Doc 157. This is how I figured this out. I was like, holy crap. Document 151. Let's pull that up, because this is really something, you guys. This is unbelievable. It is checkmate. It is checkmate. They are done. Response in opposition to request for order under FRCP 41A2, dismissing counterclaim count 1. Now, this one is just the response to count 1. Randy did not object, I think, to 2 and 3. Although I couldn't find, Tug, I couldn't find his response to that. Do you know if we have his response to the dismissal of 2 and 3?
Yes. Shit, I can't remember what number it is off the top of my head. Though.
I don't either, but it should be close to 111. It should be
God,
within.
that's so far
But
back.
right when, okay, but 111 though was a problem because 111 was right before the shit hit the fan. The judge got pissed off, and everybody's shit got struck from the record, and the case got put on hold, and there was the sanctions hearing and the bring your checkbook thing. So it might have. I don't know if it fell through the cracks or what, but I would like to see what his response to that one was. But anyway, the response to so Lynette goes and she files to dismiss. Lynette and John both go and file to dismiss claim 1 as well. And claim 1 is the intentional infliction of emotional distress in their counterclaim, thus dismissing the entire counterclaim against Jeremy Hales. Why would you do that, by the way, if you're being sued? You really have to ask the question. Why would you dismiss the entire counterclaim before there's been any ruling on the merits of it? The only explanation I can come up with is because they knew they were going to lose it.
I think it's Doc 119 because I think the order is 121.
Okay.
It's just my guess. Let me roll back.
I wonder if do we have it?
I'm sure.
119?
Yeah. They're complete when they get past a certain number. Oh yeah.
Oh, good. Awesome. All right.
Yes.
So this is really interesting, and I know it's kind of complicated. Yeah. It took me a while to wrap my head around this today, and I had to do like a bunch of studying of different rules of first civil procedure. And I swear, I think I could I might have to try and sit for the bar exam after this. I think I'm close. I'm close to being ready to pass. But okay, here we go. So this is Randy's response in opposition to the request to dismiss. So Jeremy Hales opposes the request motions for dismissal under Federal Rule of Civil Procedure 41A2 for Docs 150 and 151 and requests that the court deny these requests because Hales will suffer clear legal prejudice. But if the court grants dismissal, that it be with prejudice. And then he cites case law. In addition, when as here, a counter defendant, and with prejudice means they can't refile it. And then also he would be asking for attorney's fees right here. A counter defendant has already incurred expenses, including attorney's fees in defending the counterclaims with a pending motion to dismiss. a plaintiff ordinarily will not be allowed to dismiss his suit without prejudice, where the defendant has been put to considerable expense, except on the condition that the plaintiff reimburse the defendant for a portion of the expenses, including attorney's fees. Counter plaintiff already filed and dismissed the same cause of action once in state court 2024 in this case number. That would be the thumbnail case filed in the 8th Judicial Circuit Court in and for Levy County. Copies of the complaint and notice of voluntary dismissal being attached here too as Exhibit 1. Under the two dismissal rule in FRCP 41A1B, the second dismissal of the same claim operates as an adjudication on the merits. So do you know what that means? That means you can't refile after this. There is a second dismissal rule in Florida federal civil rules.
Right.
That means you cannot file the same lawsuit twice and dismiss him twice without getting an adverse ruling against you. It is too key. And let me tell you why this is so. I've done a lot of research on this today. And I found out there's two rules that really apply here and that are really interesting. And this is what causes the checkmate. The two dismissal rule, let me pull this up. Okay, I've got my notes here. Let's see. We don't want that. We want not that one. Not that one. Okay, so the statute protects against, wait, hold on. Where did it go? For fuck's sake, Megan, get your notes together.
God, Megan, how dare you?
The two, where did it go? Hold on. Not that one. I want the two dismissal rule. Okay, there it is. Under Rule 41A1A, a plaintiff can voluntarily dismiss an action without a court order by filing a notice of dismissal before, now this is important, before the opposing party serves an answer or a motion for summary judgment. Well, in this case, so when they dismissed 2 and 3, they had not filed an answer yet. So that was allowed for them to dismiss it, but without like an objection, right? But now trying to dismiss count 1, Jeremy already replied. There's already an answer and a motion for summary judgment, which means they can't, because the rule says, no, you cannot withdraw, you cannot dismiss if those things have already been done, because the plaintiff Jeremy has already put out money for that. Filing a stipulation of dismissal signed by all parties who have appeared. So they could sign a stipulation, but he's not going to, he's objecting, right? Mm-hmm. So a voluntary dismissal without prejudice, meaning the plaintiff can refile the case unless the notice or stipulation states otherwise. But if the plaintiff has previously dismissed a federal or state court action based on or including the same claim, a second notice of dismissal operates as an adjudication on the merits, meaning that it is with prejudice, barring the plaintiff from refiling the same claim. Ever. Ever. Guess what, Bruce? You're screwed. You cannot, Lynette and John cannot refile the same thing, whether they put it under HG's name, whether they put it, they can't. They cannot file the same thing against the same defendants anywhere. They will get hit with sanctions immediately. So the 11th Circuit has already ruled. They strictly apply the two dismissal rule. And here's what it is. It's the rule applies when the second dismissal involves the same claim or claims as the first dismissal. If they are substantively identical based on factual allegations and legal theories, then the rule applies even though different relators are filed the cases. Think about that. So if somebody else, I think what that means is if somebody else files based against him, based on the same stuff, right, it's getting dismissed.
It's a problem. And all this makes sense. This is how you get rid of vexatious litigation, which has become one hell of an issue as of late.
Yeah, this is a great rule, by the way. I was really encouraged to see that this is there, because that means, guess what that means for Lips? She's already dismissed it once against us. You got one more shot.
Whoopsie.
If you dismiss it again, you're fucked. You're not going to be able, you'll never be able to file it again. So you know what that means? If she doesn't serve us, that's it. That's the dismissal that will serve as an adjudication. If 120 days goes by and nobody gets served, that's her second dismissal, Tug. And it will apply. This is checkmate. They cannot file this again. So all of this bullshit they've been saying on the ecosystem, they've been saying, oh, we're gonna file. There's a huge lawsuit coming. Don't you worry about it. There's another lawsuit coming. No. You've filed and dismissed it twice. Then you cannot use any of the same claims. You can't use the copyright claim. You can't use the emotional distress. You can't use anything based on YouTube content. You're done. It's over. And the only thing that's left is Jeremy Hale suing you.
It's so funny to walk themselves into that corner. You know, it's not shocking, though. I mean, remember, this is the same party that told us, you can't be sanctioned for the thumbnail case. From the same legal minds that brought you.
Oh, yeah. And guess what? They can be sanctioned for doing this, too. They can be sanctioned for filing this counterclaim and then dismissing it a second time. That can happen.
Should be. He's already incurred costs.
Okay, so then there's another rule that comes into play where they are doubly screwed. And that is called, hold on, I wrote it down. It's called the not that one. That's not it. Hold on. Wait. Not that one. Not the two dismissal. Let's see. That one we just did. This is also, it's a little bit tricky. Because hold on. Because it's very technical, but I finally figured it out. And it really is, it's great because this makes me have some faith that the justice system is looking out for people who are being attacked with frivolous filings, which we have not seen yet in this case. Okay, this is called the splitting cause of action rule. This is very interesting. So the splitting cause of action rule is a legal doctrine rooted in the principle of res judicata. Now, some of you who follow a lot of the law tubers know what res judicata means. It means already adjudicated. Okay, so it's kind of similar to what we were just talking about, the two dismissal, because after the second dismissal, you have res judicata. It applies. That means it's already been decided. You're done. So this rule prohibits a plaintiff from dividing a single cause of action into multiple lawsuits. So they can't just take, let's say they have 3 causes of action, right? Like they filed in their counterclaim. They can't take one and file a lawsuit and then take the second one and file a lawsuit and take the third one and file a lawsuit. You can't do that. That you have to put them all together. But here's where it comes into play, where it really screws them. Because it says this rule is particularly relevant in the context of litigation to prevent duplicative or piecemeal lawsuits and to conserve judicial resources and ensure finality in legal proceedings. But here comes the big wow moment. This is so good. The rule is designed to ensure that all related claims are adjudicated together to avoid inconsistent judgments, and not just all of the related claims that they put in the lawsuit, but all of the related claims that might have been added to the lawsuit. That might have been added, you guys. So if Bruce is like, well, that's okay, because I'll just come up with 3 different causes of action against Jeremy Hales. If they have anything, if they could have been added into this one, he can't fucking do it.
Whoopsie.
He cannot. He is so screwed. They are so screwed. Even if they came up with a bunch of different claims against Jeremy Hales, Randy will be able to prove that it could have been added into the thumbnail. It could have been added into the second filing of the thumbnail. And so they can't do it. This is unbelievable. And again, if you guys want to look that up, it's called the splitting cause of action rule.
This could be called the worst lawyers in history rule.
Well, you know what you know why they didn't know this? Because it's rules of civil procedure, which Bruce is not familiar with in federal court. Yes, he allegedly practices in federal court for his employment law, but it turns out that in Connecticut, at least, employment cases go before a board. They don't even go in front of a judge. It's a little bit different of proceeding. He may not have actually been in court doing these. Now, I he could have been in some cases. That's true, and maybe Massachusetts is different. I think this is a Connecticut thing, but I'm not sure that he's that familiar with these rules. And by the way, I mean, who could blame them? The rules are intense. Okay, the rules of civil procedure. You have in like several classes on those in law school. Like you have to study this stuff, and they change all the time, of course, right? So you have to keep up on them too, which is why they do continuing legal education. And we know how he feels about that. We know how he feels about continuing his legal education. He finds it unimportant and claims he won't do it. So maybe he just didn't know about these rules. I don't know, but these are very secure rules that have been in place for many years. And the 11th Circuit says, like, there's no arguing it. If you've filed something twice and you've dismissed it twice, you're fucking out of luck. You're not doing it a third time. And you can't come up with new claims that have any relation to those things that you filed and dismissed. And I don't think that anybody else can do it either. So I don't think Lisa can do it. I don't think Lips can do it. I don't think anybody can file against Jeremy Hales for the same thing that has already been, it's res judicata. It has been decided. And as soon as this judge grants Randy's motion, it will be decided.
That is hilarious, man.
I know.
They do things they have no idea. It amazes me because I feel like they have no idea the kind of bullshit that they step into ever.
I know. Listen to this. Res judicata and claim preclusion. If a final judgment is entered on the merits in one lawsuit, the splitting cause of action rule bars a second lawsuit involving the same parties or those in privity. I think that might even cover me and you. And the same cause of action or claims that could have been raised. The 11th Circuit applies a 4-part test for res judicata. The prior decision was a final judgment on the merits, and if this is decided with prejudice, that will be a final judgment on the merits. Actually, even if he does it without prejudice, it will still be a final judgment of the merits because the federal rule says you cannot have 2 dismissed filings and it not be with prejudice. So even if the court writes without prejudice, it actually isn't. The prior decision was the same parties or those in privity are involved in both cases. The same cause of action is involved, determined by whether the claims arise from the same nucleus of operative facts. How are they going to file any lawsuit that isn't from the same nucleus of operative facts? And those operative facts being that Jeremy Hales created YouTube drama and litigation for content on YouTube.
The polyflop rules.
Right? I'm telling you, they are screwed. This is over. It is done. And the only thing left to do is pick at the carcass and find out how much they owe Jeremy Hales, not only for filing and dismissing these things improperly, but for the defamation, whatever this jury decides that he's gonna get.
God, they're terrible lawyers. I wonder how fast certain clientele will turn on them after this thing falls apart.
I don't know, but
God,
look, LMNOP, if you're listening, you got bad legal advice. And if they're telling you right now that you can file this separately somewhere else, they're 100% wrong. I have read the case law that goes along with this. So one of them that is very interesting, that's very easy to understand, is Roselle versus VMSB. Hold on, let me share this, because this we should read a little bit of this, because this is one of the case law deciding cases on this. Check this out. Okay. Roselle versus VMSB LLC, 2023. United States Court of Appeals, 11th Circuit. So if you go down here, today we make explicit what our precedent has implied for almost 2 decades. Federal Rule of Civil Procedure 41A2 provides only for the dismissal of an entire action. Any attempt to use this rule to dismiss a single claim or anything less than the entire action will be invalid, just like it would be under Rule 41A1, because the parties here attempted to use 41A to dismiss a single count and not an entire lawsuit. A final judgment was never rendered. We thus lack jurisdiction to hear this appeal, so we dismiss it. So then if you go down a little bit further, right here, here it is. Federal Rule 41 governs the dismissal of actions in general, and 41A outlines the procedure for voluntary dismissals at the party's request. 41A1 explains how a plaintiff can dismiss an action without a court order, and Rule 41A2 specifies that when an action can be dismissed at plaintiff's request by court order. Here, neither the court nor any party explained which section of the rule authorized the dismissal, but it was procedurally improper either way. Rule 41A1 cannot be used to create appellate jurisdiction over a partial grant of summary judgment. As the rule's plain text says, a joint stipulation of voluntary dismissal may be used to dismiss only an action in its entirety. So them trying to dismiss just 2 and 3 or just 1, that doesn't work either. It doesn't. Like you have it factually dismisses the entire thing. Because if that were taken up on appeal, the appeals court has already ruled on it. You can't just dismiss 1 or 2. You have to dismiss the whole thing. Look at this. We recently reemphasized our Perry holding, noting that Rule 41A does not permit plaintiffs to pick and choose, dismissing only particular claims within an action. What? So I don't even think they should have gotten away with what they did before with 2 and 3, but I think because Randy didn't object, I think that's why it was, if it was granted at all. Did we pull up, what did you say the number of the document was that I was looking for? Randy's response?
Give me 1 minute. I've got it.
I think you said 119.
Mm-hmm. Yeah, or you want to pull it?
It was 119. Yeah, hold on, I'll pull it up.
119, and the court order is 121, I believe.
All right, so let me.
It'll say on there. So
here it is, 119. Let's pull up 119. Let's open this, and we will share this. Boy, this case is so interesting. God, I'm learning so much. It's crazy. It's so interesting. It really is. It's days like this where I'm sitting at my computer and I have an aha moment where I'm like,
right.
Oh my God, this is why I do this. This is why I do this, because what I've learned here today, I will never forget. I will never unlearn this. And this, it's just so interesting to me. And maybe just because I'm a nerd, I'm like a law nerd, I can't help myself. I find it really interesting. And I'm happy to have found a rule that protects people from frivolous litigation, you know? Like, I'm really thrilled about that. So here's Randy's response to the request to dismiss the counterclaims 2 and 3. Jeremy Hales responds to the request for order under FRCP, whatever, dismissing counts 2 and 3, and states, plaintiff does not object to dismissal of counterclaim 2 and 3, but does not agree with the request to the extent that it states dismissal will render moot the motions to dismiss 109 and 110, eliminating the need for the court to rule on these motions. This is because the motions to dismiss docs 109 and 110 also relate to count 1 of both counterclaims for both intentional infliction of emotional distress, which still remain pending. Thus, the dismissal of counterclaim 2 and 3 does not eliminate the need for the court to rule on the motions to dismiss 109 and 110 as to count 1. Okay, interesting. But I think if he had wanted to, he could have argued that they had to dismiss the entire thing. based on what I just read from the appeals court, I don't think that they have a right to just dismiss 2 and 3, which is interesting. Really, really interesting. But okay, let's go to the order. You said the order was 121?
Yeah, I believe so.
All right, let's go to 121. Ooh, this is fun. We're going on a tour through the documents. 121.
Remember somebody volunteered to organize Fed 2 the other day.
I know, that was me, wasn't it?
But it was indeed.
It's still not done.
I will hold you to that one.
No, I'm going to do it. I am. All right, let's see. Open. All right. That is my penance, by the way. I said I would do it, and I will. All right, let's see. This is the order then for counts 2 and 3. Referred to the judge for dismissing 2 and 3. Upon consideration of the foregoing, it's ordered. Defendants have moved to voluntarily dismiss 2 and 3 of their counterclaims. Plaintiff does not object. Accordingly, defendant's motion is granted to the extent that counts 2 and 3 of defendant's counterclaims are voluntarily dismissed without prejudice, allowing the court to voluntarily dismiss claims upon the claimant's request. But do you see how this says without prejudice? It actually doesn't matter whether he wrote with prejudice or without. It is with. It's actually with. Because if they file this again, Jeremy is going to get an automatic win because they filed it twice and dismissed it twice. So it won't matter what this says. And the reason why it says without prejudice here is because Bletho isn't the judge in the state case. Right? He wasn't made aware of the state case where it was dismissed. And that might have been maybe Randy overlooked that. I don't know. But he wasn't made aware of it. Once a judge is made aware that this was filed twice and dismissed twice, it's game over. Game fucking over.
Oh, I'm proud of them.
Mm-hmm.
I'm proud of them. It takes a special something to make me think, wow, how the fuck. And they brag about being a nest of just all these great lawyers,
Oh, yes, they're really great. Mm-hmm. Yeah, really, really good. Really, really good. Where's that button?
This will get awkward.
All right, let's go back. Let's go back to the most recent filing that we were looking at. Randy's filing, his response to the dropping of count 1, which is what made me think about this today, which is what made me go and look this stuff up. So he brings it up here. Under the 2 dismissal rule of 41A1B, the second dismissal of the same claim operates as an adjudication on the merits. Record activity and judicial administration requires denial of the request for dismissal under FRCP 41A2. The court should consider whether there has been record activity and whether dismissal would create significant problems of judicial administration. There is currently a pending motion to dismiss on these counterclaims, which has already involved judicial and attorney resources. And we just read that in the rule. That if there is wouldn't you like to know? Don't worry. He says, Megan, you're giving them information. It's too late.
They already did it.
They already did it. They can't go back in now and refile it. Do you understand? It's too late. Checkmate. They can't. There's nothing he can do about it because they already filed to dismiss the same case that they dismissed in state court. They fucked up big time. It's game over is right, Happy. Game over. I wish I had that little that I know the noise I want on my soundboard. A soundboard. When you die in a video game. It's exactly what we need. Sad trombone might work though. Over. It's over. It's over. They cannot bring this again. And they have dropped their entire counterclaim. So now they're going to end up paying attorney's fees because they dropped it after Jeremy spent money to respond. Do you see? So now she's on the hook for more attorney's fees. All right. That's the amazing. Court, don't worry, Max Lab, that Jeremy's not here to hear this. His attorney already knows this, and we're reading about it right now. There is currently a pending motion to dismiss on these counterclaims, which has already involved resources. Thus, this is an attempt to avoid dismissal on the basis of merits right at the brink of when a decision on the merits is pending. That's right. That's exactly what it is. And you can't do that. Since there has been recent record activity in this case, dismissal would be improper as it would undermine judicial efficiency and waste resources. The counter defense, and we know how this judge feels about wasting court resources, don't we? He doesn't like it.
Supposedly he doesn't like it.
Yeah, supposedly. The counter defendant respectfully requests that the court deny the motions for dismissal under the rule. Alternatively, the 2 dismissal rule requires dismissal with prejudice. Counter plaintiff has already filed and dismissed the same cause of action once in state court in 2024. See the attached filings in case number blah blah, filed in the 8th Judicial Circuit Court in Levy County. If a plaintiff has previously dismissed any federal or state court action based on or including the same claim, a second dismissal operates as an adjudication on the merits. The 11th Circuit has recognized that the primary purpose of the 2 dismissal rule is to prevent unreasonable abuse of the plaintiff's unilateral right to dismiss actions and to protect defendants from harassment through repeated filings and dismissals of the same claim. Seeley v. Branch Banking. But under the so-called 2 dismissal rule, if the plaintiff previously dismissed any federal or state court action based on or including the same claim, a notice of dismissal operates as an adjudication on the merits. We have said that the primary purpose of the 2 dismissal rule is to prevent unreasonable abuse of the plaintiff's unilateral right to dismiss an action. This means that allowing dismissal without prejudice would unfairly prejudice the counter defendant and contravene the purpose of Rule 41. Here, the prior dismissal in state court triggers the 2 dismissal rule. The rule applies regardless of whether the first dismissal occurred in state or federal court, as long as the second dismissal is in federal court. Therefore, the court should dismiss the counterclaims with prejudice to prevent further abuse and to protect the counter defendant from the burden of defending against repetitive litigation. And let me tell you this, if this judge does not dismiss this, straight to appeal. That's what I would do, straight to appeal, because the appeals court's already ruled. They've already ruled on this multiple times. Dismissal without prejudice would cause legal prejudice to the defendant. Granting a dismissal without prejudice would unfairly prejudice the counter defendant. The repeated filings and dismissals of the same cause of action have already caused the counter defendant to incur unnecessary legal expenses and wasted judicial resources. Allowing dismissal without prejudice would leave the counter defendant vulnerable to a third litigation on the same claims, contrary to the purpose of the rule. The 11th Circuit has held that the purpose of the rule is to prevent voluntary dismissals that unfairly affect the opposing party and to permit the imposition of curative conditions. While the mere prospect of a lawsuit is not sufficient legal prejudice, the prior dismissal in state court and the attempt to dismiss again in federal court demonstrate a pattern of conduct that unfairly burdens the counter defendant. Boom!
Oh, you gotta love it.
And you know, this is such good evidence that this is all about harassing him.
Yeah, that's exactly it. I mean, it does. It reads like harassment. You know, Lips made it even worse too, because what did she do while we were sitting around waiting for something to happen? She took the lawsuit she filed, didn't just put it in Fed. I missed this. This is something I missed. She put it in Fed too, but she also added the documentation to the thumbnail case.
Yeah, she did. And you know what? I truly believe that I think you could make the same argument against that because the same parties or those in privity are involved in both cases. Remember when I read that? The 11th Circuit appeals the 4-part test for res judicata. The same parties, well, Jeremy Hales or those in privity are involved in both cases. If she is filing something that's based on this same lawsuit, I think that this applies to her as well. And she did. She made the argument that he is doing it for YouTube content.
Not just that, it was brought up in Fed too. It's being utilized as ammunition by none other than 2L1. So
oh my God.
It's even being brought up in filings. It was like a big portion of her filing. Yeah. So I
Well.
mean, I think you can make an argument when you look at it and you look how it connects and everything else. It'd be a fascinating argument to see, if nothing else.
Yes, it would be.
Unfortunately, you know, when you slap it down, like the slap law alone that's attached to that, God, there's so many different problems that thing has. But yeah, if Germany, God, they hit that thing and hit it hard, oh my God, this could really screw them up.
Oh yeah, I know. This is getting so interesting. My God, just when I start to get bored by this case, and I wish I was covering something else, something like this happens, and I'm like, oh, I can't wait to see what happens. I can't wait. You know what I mean? Like it's unbelievable, and I'm learning so much throughout all of this. I'm learning. That's what I love about covering these cases. Every case I cover, I learn something new about the law. And it's like it's like going to law school. You know, I learned something about, like today I learned about federal civil procedure, 2 rules that I bet people don't talk about very often. I've literally never heard the 2 dismissal rule, and I've never heard about the other one too, whatever the other one was. It's not the one publication, it's the other one, splitting the cause of actions. I hadn't heard of that one either. And that I think has completely backed them into a corner. I think that this is checkmate.
Well, you know,
there will be no more lawsuits filed, you guys. There will not, without sanctions. Oh, and that's the other thing. You want to go ahead and file this again, you guys? You want to file, those of you thinking about filing against any of us based on this bullshit again, you're going to get hit with sanctions. You will pay attorney fees. You look up the 2 dismissal rule.
The lips filing is totally based on YouTube and some supposed conspiracy. So I mean, it very much is the same kind of bullshit. It is the same claims over again.
It is the same claims, and I think it applies to her now too. So it's very interesting. It's very interesting. So to finish this up, the request for dismissals should be denied. But if the court is inclined to grant dismissal with prejudice is necessary to prevent further prejudice to ensure finality. Courts have discretion to deny dismissal or impose conditions to ensure fairness and prevent abuse of judicial process. For the foregoing reasons, counter-defendant respectfully requests that the court deny the motions for dismissal. In the alternative, the counter-defendant requests that the court grant dismissal with prejudice pursuant to the 2 dismissal rule. Such a dismissal is necessary to prevent further prejudice to the counter-defendant to ensure fairness and uphold the purpose of Rule 41. Then we get over to his exhibit. Now, this you will recognize as the thumbnail lawsuit, okay?
AKA the worst lawsuit I have ever read. I don't know. It is pretty bad. I don't know if it can be the worst I've ever read again, but it is pretty fucking bad.
Well, we're not going to read the whole thing, but I highlighted some parts.
Have you read this thing in a while?
I have. I read it today while I was highlighting. God. It's terrible.
Yeah, I read it. Read it about a month ago again, just to to remind myself of the thumbnail litigation and trespass. I wanted to remember it all. And holy God, man! I mean, actually, I think the Trespass 5 is probably the worst one I've read, but this one's pretty dumb. I think about them together. They're both
Trespass
awful.
5 was worse. Trespass 5 was so much worse, where they kept mentioning Jeremy Hales and he's not a defendant in the case. That was so much worse. This one's bad too, but I mean, that one was so laughable.
That one was, yes. It was upsettingly bad.
It was upsettingly bad. Yes. That's a good way to put it. It was upsettingly bad. It made you want to break things, So what I did was I highlighted in here the things in this lawsuit that are exactly the same as the things in their counterclaim. So here's one. Beginning in 2023, defendants Hales and George fabricated a reality drama for content on their YouTube channel, What the Hales, centering on plaintiff Miss Preston and her ex-husband with whom she resides, John Cook. And frankly, the theme, this reality drama theme that was in there too, Hales and George have stolen Miss Preston's and Mr. Cook's live for content on their YouTube channel, subjecting them to harassment, bullying, defamation, invasion of privacy, and thousands of menacing, vulgar comments by What the Hales fans. You know, I just thought of something. If the judge orders this with prejudice, dismissed with prejudice, that sets precedent also. It's res judicata. I'm telling you, this is game over for their whole plan.
You know what's fascinating?
And the rest, and anybody else who tries to come up against any YouTuber with this bullshit they're gonna reference this case.
You're gonna slam into the wall a bit. That's funny. You know what's weird too is now, okay, back with that they're blaming fandom. Right. They're saying, well, Jeremy Hales is responsible for that fandom. And it's fascinating because I was looking through commentary of Ray Ray's newest video. And on there, I was noticing that creators are not responsible for their audiences anymore, according to their commentary. Oh my God. I was taking clips of screenshots, you know, that Ray was liking and commenting on.
Oh,
that was one of them. Yeah, so I was like, wait a minute. Back in this lawsuit, Hales is responsible for everything that goes on. You know, if some random person out there, they go and they exercise their free speech, well, apparently it's somehow Hales' fault. But it's not their fault if something happens and it goes the other way.
Right. Yeah, it doesn't make any sense. So I have some
It
other
just changes all the time. Anyway.
So then we have count two. So 540. So all of this stuff about 540.08, that was in count 2 and 3, 2 or 3. I don't remember if it was 2 or 3, one of them. So that's all the same. And then let's move down. Okay, count 5. Injunction versus all defendants. The plaintiff will suffer irreparable harm if she's not granted a permanent injunction. So this is the intentional infliction of emotional distress claim, right? So here it is.
Mm-hmm.
This is the same. It's the same crap. The same crap. He's absolutely 100% right. They filed the same thing based on the same core facts. Same core facts. They cannot do this. You cannot file two things, dismiss both things, and then do it again. And I think it's hilarious that they even have said we're going to do it again. That's why we're dismissing it. We're doing it again.
They said it in their filings. That's the crazy thing. They didn't just say it out here live. They put it in fucking filings.
Yeah, they said they were going to do this. They're admitting that they are going to file it a third time. And if Randy needs, I wish Randy had quoted that. I wish he had quoted it. Because look, he should have quoted this in here because they notified of their intention to file it again right there. Let's pull in on that right there. The defendants wish to pursue these claims in a separate action in their forum of choice. I wish he had quoted this, because not only he's saying in his Doc 157, they could file a third time to harass, but they said they were going to.
Yep.
They literally said they were going to.
It's amazing. Like, this fucking stuff is crazy.
I know the chat seems confused. There is no new judge in this case. Federal case is Judge Belitho. The state case is Judge Davis. There are two judges involved in the ongoing cases involving Jeremy Hales. Belitho and Davis. They're not in the same courts. So one's in federal and one's in state. But I don't know, somebody in the chat, not the entire chat, you guys know, but someone was confused about that. I just wanted to point that out. But yeah, they admitted it. They admitted it, what they were going to do. And you can't do that. So I think this is checkmate. I think that the judge has no choice but to dismiss. Well, he has two choices. He can deny the motion to dismiss, which I'm not sure why. See, the one question I have is why is Randy, and I'm sure Randy has an explanation for it. I just don't know what it is. Why is he arguing to not dismiss it, to just leave it in there? Maybe because he thinks he's going to win. That's why he thinks he's going to win on his response to it. That's why he wants it in there, because he's going to win on the merit. Yes, that's what he said in the filing. He will win on the merits of the response. And so he doesn't want it dismissed. But if the judge is going to dismiss it, then it has to be with prejudice. And then you have your adjudication on the merit anyway, because it's as good as an adjudication on the merit. Oh my God, it's a checkmate. They're done. Unbelievable. All right. What was the other thing we were going to read today? There was something else.
Their other filing. Haven't looked at.
Right. Was that in
Remember
Fed?
his? Oh well,
Fed
it was
1 or Fed 2?
It was the Fed 2 discovery filing. Actually, that's what we were talking about. What is that?
Right. Okay. Fed 2.
2, 4. I don't remember. I got to put in 55, 56, and 57.
Fed 2.
No, it's Fed 1. Oh, Fed 1. Fed 1.
Oh, it is Fed 1. Oh,
yeah.
okay.
You're. We're talking about. Remember the discovery?
Oh yeah. Discovery. Okay. Wait. Hold on.
So
Federal.
that'll be
court.
152. I think that's plaintiff's second motion to compel for production. What's throwing me is, remember, he filed it as 148, and then it ended up having it got kicked because of the judge not reading it and separating. Jesus,
Yeah,
I was like, "Are you kidding me? Did you really not read that?" Judge?
Yeah, that was annoying. All right,
that was more than annoying. It was like, "Are you? You did not read the filing, judge?"
Yeah,
because it clearly showcases that they were separated.
I can't explain how or why.
Oh my God, there was another thing too. Let me note this as well. Okay. So in that 2L filing, the other thing that was in there that was really funny is she was complaining that Randy hasn't had communication with her, right? But then she included an email from Randy where he had communication with her.
No.
Yeah.
Do you have this?
Oh yeah, it's shit. Give me a minute. I may have it still pulled up over here. Just give me a minute. I gotta find it. There's so many of them. You can hear me. I'm filing everything away, and I know where it goes.
Well, while you're looking for that, we'll get to a couple more super tips that I have waiting for me. By the way, super tips are so much fun, and they are for parody and comedy only. To use fun AI voices to have your words read aloud on the show, like Max Lab here, who sent $5. And it's not playing. Why isn't it playing?
Like Max Lab here. Crickets.
Like Max Lab here. Oh wait, that's because it's not one that's being. It's a chat. Okay. Wait, no, it's not. It's Vice's. Why isn't Vice's voices playing? Hold on. Let me try it again. Oh, I know why. I must have the.
No new court documents all weekend long and nothing today.
No new court documents all weekend long and nothing today. Yeah, that's good that we didn't have anything because we still have a lot of catching up to do. And by the way, I heard you, Tug, say something that really lit a spark in my mind over one of your multiple streams. I don't know which one that I wasn't a part of, where you said we should do a catch-up stream someday. I definitely want to do a catch-up stream for everybody who wants to follow this case but has found themselves behind or lost at some point. And I'm going to put that together. We're going to do that. It's going to be good. Buck Naked, thanks for the 5.
I understand the fleas have a new venture. Onlyfood.com. Your subscription entitles you to watch them eat in lingerie.
Oh, God, no.
Oh, God, hell no.
No.
Hell no.
No, I don't want to see that. I'll be scarred forever. Ryan Poole, thanks for the 5.
If Megan won't share, I'll bully Nick into sharing. To clarify, I'll bully him in the form of money. His big nose self can't resist green cash, even if it's not rolled up into a tube.
green cash. Gotta get that green.
Get that green. Michelle Natal, thanks for the 5.
Hey, Megan, how many LULYERs does it take to lose a case? 5, maybe 6. The goddamn assholes do not know how to do anything to help their case. What idiots! Love you, Megan. Get to bed early.
I can't believe how much that sounds like my dad. It's so great. SF, thanks for the 5.
Maybe 2L isn't just my lawyer, but maybe she is Ray's lawyer too. Sorry for the punctuation. Trying out something new.
Oh boy, Rosalind Duke sent $16, and you know what that means. There's going to be a lot of chats here.
Strategy, schmategy, tragedy. This new edition of the Brothers Grimm is weird.
Oh, hey, Jeff, chat. Follow me for more insight into my ideas about how to deal with these clowns.
Hey, Nick, calm down, dear. We can't have chat running the show.
I will tell you my story. I will tell it and tell it and tell it like only I can tell it. No matter who I implicate in the process.
Well, tell it.
It's my voice and I cannot be stopped. Never my voice. I need my...
Jesus, John, Jacob, Ingelheimer, Schmidt. Enough. I'm taking my fairy tale to the Supreme Court and nobody seems to care. It's me time already.
And Richard, thanks for the Cash App for the 10. Says for breadsticks. I appreciate that. Thank you so much, Richard. And Lisa Carper, thanks for the 5.
You think you're so smart. Well, you take your breadstick begging butt and your little mascot. I have turtles and trash and fleas and people holding money donated to me. You are just jealous.
That's very, very jealous. Oh my goodness. And Lisa Carper, thanks for the 5. And it didn't play. Why didn't it play? Let's try it again. Nope. It says, oh, it's a chat, but it won't go up on the, that's weird. It says, Megan, I'm still waiting on my check from Jeremy Hales. He's late on our talking points for tomorrow. How am I supposed to know what to say? I know. This is very disturbing.
I've got some amazing breaking news. You want to see it?
Yes. Wait, we need the music. Hold on. Where's the breaking news music?
Yes, today we have something breaking behind the scenes. We have video of new postings. Check it out. Pull this up there. Look at this. Oh my God. Look. The germ says I'm not a supermodel. Donate. Oh my God. Oh my God.
Oh no!
Yeah, look at all of these. Look
at how many you've made.
Look at her. Oh my God! I'm gonna type it out.
Was she seriously complaining about that? That
No.
someone said she wasn't a supermodel?
No, she wasn't. I just thought it was
Very funny.
I'm not a supermodel. Oh my God. Like, that's not catfishing. There needs to be a new word. I was trying to figure it out. I was like, what could you call it? Flea skinning? You know? Yeah. I was like, I don't know why. The other night when I was talking about it, I called them dirt pixies, you know? I was trying to think of new ones, you know, like gutter buttes. That would be a good one too.
Gutter buttes.
Yeah, gutter buttes would be really nice. It's not
Martin
catfish. It's
fat
like a fake
fishing.
leech.
Fat fishing.
Fat fishing. Oh my God.
Oh, it's so good. It's so good. Oh God. Okay. Did you find the thing you were looking for?
Oh yeah. Yeah, I had time to find it, and I made something stupid while I was. God, this is pretty good though. All right, so this whole file, I'm telling you, if you've not, this filing is amazing. There's so many problems with it. First of all, like I said, when you're going through.
Wait, whose filing was this again?
This is 2L's filing. Remember? With
right. Okay.
Yeah. So I mean, throughout this, it's got so many great things. First of all, it's just all blathering and opinion. There's nothing really here anyway, and you can see though it really goes off the rails. Like, look at how it's set up at first. Now follow this. Okay, you see it's blathering through its points, blah 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 blah, and then it gets to lips here, right? And you'll notice after it does that, it starts numbering. Okay, you would think that would stand to reason. Anything numbered after this, right, would be part of her filing. So it starts out like that. First, you can see, you know, here's the whole subscriber conspiracy, fake account.
Oh my God, I just realized something. By Lips doing this, by putting us in a lawsuit with Jeremy Hales, I think she made us those privy people to the lawsuit, to the same filing.
Yeah, that's just...
Oh my God.
Oh, it's
I
so
think
amazing.
she did. I'm going to have to run this by lawyers I know, but I think I'm right. All right,
That's
sorry.
so
So it's
funny.
being numbered. Gotcha.
Yeah. Now, when you get down to the bottom, though, it keeps numbering and it starts bringing up Ray. And it's like, wait a minute. Because again, before this, it wasn't numbering.
Quoting? Wasn't she?
Yeah, she's
quoting
quoting the case, or she's paraphrasing the case. It's not really, some of it's quoting, some of it feels like paraphrasing. But where does it start and where does it end? Because it keeps going and it's talking about Ray. Now, Ray's not part of that at all, you know? So she keeps going like that's part of the case that she's talking about.
Oh my gosh. And
Yeah.
I don't think Lips mentioned Bone Crusher.
No, that's nothing. This is all about her wanting to keep Ray out of it. You know, I mean, that's the whole point in all of pretty much all of this mess, I guess. I mean, it's a very confusing thing. But now you get to this here too. In Doc 63, counsel for plaintiffs states that, you know, in certificate of good faith conference, claiming they conferred, but they couldn't resolve things, right? Well, he's never contacted her. You see that, right? Never contacted, right? Never. Okay, well, it's interesting because when we roll down through our exhibits, we get to right here. And what is this? This is Randy Shockett communicating with 2L.
Oh my God. And look at, she's asking him, please let me know if you consent to a 30-day extension of time for my response. And he says, we do not. Please reply to this email address for all future matters in this case. That's unbelievable. So she's saying they didn't confer, and yet here.
Yeah. No, there was never any ever. You notice we've never conferred. And yet in their freaking, oh my God, I was like, how could this happen? You know, you've never conferred at all. But there's you conferring.
That's funny. I like Steve Robillard. Look at Steve Robillard's Muppet. Oh my God, is that Judge Grudge? Because it looks like Judge Grudge.
It does look like it.
It is
really
so
does.
funny. But he says, since they are all, including Ray, want to lay into his service to his country, you should get a button that plays God Bless America every time his name comes up. I have something better. Every time Ray is mentioned from now on, I'm going to hit this button. Perfect. Perfect. I love it. I love that idea, and I love your Muppet. That Muppet is fan-freaking-tastic, let me tell you. All right, so... oh my God, Linda Brucker sent a super tip that you have to hear right now. It is freaking hilarious. Thanks for the 5.
My case is dead. My case is not dead.
And Keith Peavy House also.
I'm driving from CA to NY, currently in Indianapolis. It's hot. You're helping me to be entertained, stay awake, and not die in a fiery car crash.
Oh, fantastic. Please don't die in a fiery car crash. That is definitely not recommended. And thanks for being here and listening. And I hope that we will keep you entertained, at least until you stop for the night. That's a long ass trip. I hope your car is doing well on that, especially in all the heat. I will never forget one time we were traveling in California through Death Valley on a family vacation. And it was like, I don't know, 112 degrees or something crazy. And we were in my mom.
I gotta say,
Sure.
kids are stomping. Let's went through.
Okay. And we were in my mom's Woody wagon. She had a station wagon, and it overheated. And the dog was in the car. I will never forget this. I was really little. And the dog was in the car. We had the standard poodle. And he was overheating, and we were stuck on the side of the road in the middle of the desert with an overheating car, no air conditioning, 112 degrees, or wherever it is, Death Valley, Nevada, whatever. We were going from California somewhere or to California. I don't remember. I was little. So yeah, maybe it's Nevada, but it was awful. And I remember my mom was getting really worried. I don't remember if my dad was there. I don't think he was. My mom, we used to travel without him because he worked so much. But I think that was back in the day when she had a CB. And so she got on the CB and called for help from truckers, and they came through. But the dog was like, oh, I remember the dog just being so overheated, and I was so worried he was going to have a stroke or something. Because I don't even think we had water. That was back in the days before bottled water. If you wanted water, you had to bring a thermos, you know? We probably went through it. I remember my mom getting scared because it was like the midday and it was over 100 and the car was overheating. Yeah, why do you think it's called Death Valley? Yeah, no kidding. I know. I don't know what we were doing there. I don't remember. I don't remember what vacation that was. But yeah. So anyway, we are going to, while Tug's gone, I'll play a couple more of the super tips that we have here. Actually, no, not super tips. Sorry. I meant super chats. We have a couple of them. Dwayne Rapp, thanks for the 5. Megan Fox, can you put J-Hip on the super tips voice? Yes, I can do that. I need to make a list of more voices that we need, and I can certainly put Jay's voice on there. That would be funny. His voice is hilarious. Max Lab, thanks for the $1. I appreciate you. And Ruth Mobley, thanks for being a member for 13 months. Alex Marie, thanks for the $10 super sticker. I love your Muppet avatar. So funny. Rickles64, thanks for the 2. Take a quick okay peek at email. Okay. Hold, please. Checking email. I don't have my email open. I have to log in. It would be funny if I played the hold music until Tug came back and we just sat here listening to hold music while he's gone. All right, what am I looking for? The Cash App I did mention. I mentioned the Cash App. Richard sent it to me. Thank you very much. Let's see. Oh, the game over sound. Somebody sent me the Pac-Man die sound. Was that from you? I'm so glad. I'm going to add that to the board. That will be hilarious. What else do we have here? I think that's it. Okay, awesome. Thank you so much for the Cash App and for the Pac-Man dying sound. That's perfect. I have a space on the soundboard just for it, so that'll be great. All right, let's see. Wender Bender, thanks for the 5. Hi, Megan, Tug, Mods, and chat. We had the heat here in Wisconsin Saturday and Sunday. Yeah, it was pretty hot over the weekend here too, but today was even worse. I stayed inside today. I was outside all weekend. I was enjoying the heat, but today I decided to stay in. Lori Netzel, thanks for the 10 gifted Megan Fox memberships. Wow. Welcome to the Fox Den, all of you. It's weird here, but you will get used to it. And if you don't, it's too bad. You're stuck for life. You're a lifer now. Audie TT, thanks for the £2 super sticker. I appreciate you, and I love your Muppet. That is adorable. Lady Jen, member for 2 months. Love your channel, Megan and Tug. Well, thank you so much. We love you, and we love your avatar, and we're so glad that you're here. And Oporowski, thanks for the 5. I appreciate you. Just J Hip, thanks for the 5. Megan, I'm acting as Tug's counsel. Would you like me to be your lawyer as well? I'm pretty good at this, and I know law stuffs. Yeah, I'm not sold. I'm not sold, Just Jay. I'm going to have to wait to see what your first opening move is for Tug. I don't know. I have a bad feeling about this. I'll just put it that way. I've seen how you, I've seen your streams. I'm not sure that I want you doing my legal work, but I could change my mind. I don't know. It depends. Maybe not. Gifted 5 Megan Fox memberships. Thank you so much for the gifted memberships, and welcome to the Fox Den, all of you who just got those. Oh, and Jay, by the way, I will say this, though. As long as I'm not served, I have no problem with you acting as my counsel in a fake lawsuit. You could be my fake counsel in a fake lawsuit, because this lawsuit is not real. So maybe I am changing my mind. You could be my fake counsel. Sure. Jackie Hampson, thanks for the £5. Hey, Megan, here's some breadstick money. Loving the channel. Well, thank you very much, Jackie. I appreciate the breadsticks. Willie Borza, thanks for the Canadian 10. Celebration breadstick time. Excellent. Tug, are you back yet? He's still not back. Uh-oh. Janice Wingfield, thanks for the 10. Does Lynette have a new attorney yet? I don't think so. And she has until, isn't it this week? Isn't it? It's this week, right? That she had, let's see if I can find out. Let's see. So she put in her motion for more time, and that would be Fed 1. Let's see. Requesting leave to file second motion. No, that's not it. All right, when did she do this? Plaintiff's second motion to compel. No, it's probably before that. Maybe it's this order. Let me open this and see. Okay, so on May 29th, there was an order that said this case was stayed until April 14th to allow defendants time to obtain new counsel. On May 29th, the court held a telephonic hearing to determine the status. During the hearing, defendant Preston stated that she was in the process of retaining counsel. She requested a 14-day extension to finalize her representation. Plaintiff did not oppose the extension. Accordingly, the case remains stayed. The court will hold a hearing with the parties of 14 days. The stay will remain in effect until the order of the court. Defendant should not anticipate any additional extensions. I think that was the last one. So that means 14 days from May 29th. Hold on, let me look at the calendar. The 29th, 14 business days, I think. Or is it 14? Do we know if it's 14 business days or 14 like days in general? Let's go with business days. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. The 14 days would have been June 18th. And it would have been even sooner if we were counting weekends. So that 14 days has come and gone. Was there another extension after that? I feel like there was, because this judge is such a pushover that he keeps extending it. So that, let's see what this order was. There's another order, number 149. We have, no, that's about the motion for discovery. So it's not that. I feel like there was another request for her to get more time. Hold on. Here's an order for 153. What is this one? No, this is an order to plaintiff has moved to compel discovery responses from defendants. Defendants will have an opportunity to respond to the motion. Accordingly, defendants must respond before June 26th. Uh-oh, that's coming up soon. That's in 3 days. So their motion for the discovery needs to be responded to in 3 days. I doubt they're going to do that. So no, I do not think she had another extension after that one, and she was supposed to have an attorney enter into the case by June 18th, and that did not happen. Let's see, 154 is an order as well. Let's look at that. No, that's about the dismissal and asking for a response. Yeah, no. She has not asked for another extension, and he said she wouldn't be getting one. So I believe that the opportunity, that it's come and gone. She is now pro se. Huh. The judge said during the hearing that she only had a few days to get a lawyer, otherwise she's by herself. Well, the order says she had 14 days from May 29th. Yeah, I remember when she said that she had, where was that thing where she filed about being in the hospital? Why can't I find that? Is that in Fed 2? Maybe that's Fed 2. Hold on, let me look. Hold, please. I hope the girls are okay. Tug has not returned. Fed 2. He's not usually gone this long, so I hope it wasn't anything bad. I hope nobody's hurt. All right, I am looking for the motion to I'm looking for the agreed extension. Here we go. Here's an extension. Let's see what this is. In Fed 2, we have... No, that's about Helm. Because I'm not finding that hospital thing in... Order. Oh, yeah, I really do need to... I need to reorganize this file. Damn it. Amended complaint for damages. No, that's not it. Scheduling order. This is about a scheduling order. That's document 50. Oh, we're missing a bunch of files in this one. So I don't know. Maybe MaxLab knows. MaxLab, do you know which case the hospital thing was filed in? No, you're thinking of Stark, who filed the hospital thing in the thumbnail case. Lynette filed oh my God, I need more time to get a lawyer in the Fed case because she said she was in the hospital with her daughter. It was Fed 1, and we saw it in Jeremy's video. He gave her till the 26th. Well, that's the same day discovery is due. So you're saying he gave her till 7 more days. I bet that is what it was. But why can't I find it? It should be there. Our Fed 2 or Fed 1 case is very well documented. Where is it? I'm not finding it in Fed 1. Anyway, it doesn't matter. Let's move on. Okay. So, it's in Fed 1, lower down on the order. Which order, though? I need to know what document number. Fed 2, 64? How could it be? How could it be Fed 2? Well, if it's 64, document 64 in Fed 2, then I don't have that one. I don't have it in my file. I probably have it in my email. But let's just say I think she got 7 more days from the 18th. And if that's the case... Then we are looking at 1, 2, 3, 4, 5, 6, 7, the 27th, which would be this Friday. So, 26th or 27th. Okay, that makes sense. So I guess once she hits that, she is going to be without a lawyer. All right, I'm going to take Tug off the screen because he's not back. He knows how to put himself back in, but I haven't heard from him. So obviously there's something going on over there, and hopefully it's nothing bad. Okay, Starchasm, thanks for the $20 super tip.
I hear Jay Hipsharts whining in my sleep, mainly nightmares.
If Enyomi wants a clip of Jay laughing so hard he peed in his poised panties, I will send it over.
Love you all. Smooches. I got to be up earlier than the police raid on my casita.
By the way, the police raid on the casita, that I cannot wait for that body cam footage. It is going to be excellent. It's going to be very good. So we're waiting on that. Okay, I'm going to bring up the motion for, what is it? It is the second motion to compel the production of documents and motion for better responses from defendants Preston and Cook. We have not read this yet. And I'm going to pull this up so we can take a listen, because they have not turned over anything. And as you know, in a case, that's unfortunate. Let's ask Grok, what happens in federal court in Florida if defendants in a civil case don't turn over any discovery.
All right, here we are.
Oh, you're back. You good?
Yeah. The kids were playing. They've decided that, and I already knew they were going to do this. I just didn't know they were going to do it right now. They've decided they're going to start prepping some French fries. You know, they got some. They got some potatoes to make French fries. Yeah, so it's Mr. Potato Head's worst nightmare upstairs. Yeah,
well, as long as nobody
holy
cut
God.
themselves.
No, they were having fun. They were being loud and bouncing around. I thought, what in the world are they doing up there? You know, it sounds like an elephant stampede.
Okay.
So I went and checked, and yeah, it was the excitement of, you know, like I said, it looked like a Mr. Potato Head torture chamber up there.
Okay, well, that's good because I'm relieved.
Yeah,
I
it's all
was
good.
getting worried. All right, so I just asked Grok what happens in federal court in Florida if defendants in a civil case don't turn over any discovery. So it says the federal court in Florida within the 11th Circuit, if defendants in a civil case fail to turn over discovery as required under the federal rules of civil procedure, particularly Rule 26. Uh-oh.
Oh, no.
Several consequences may follow. These consequences range from court-ordered sanctions to severe penalties like default judgment, depending on the nature of the non-compliance. In the case of circumstances, in the court's discretion. Uh-oh. Well, if it's up to the court, he won't do shit. Below, I'll explain. Yeah, you know, it says below, I'll explain the process, potential outcomes. I don't want to read all those. I just want to know what are the possibles, which is Rule 26, which would be imposes sanctions. Rule 33 governs interrogatories. Rule 34 governs requests for production. And so they could face sanctions. They could face attorney fees and costs. They could, the court may exclude their undisclosed evidence or witnesses.
Yeah, that's actually what Randy's, you know, this is an amazing document, actually. It's quite amazing.
Yeah, let's read it. Shall we take turns? You want to start with the first page?
Yeah, give me a second here. Yeah, sure. Plaintiff's second motion to compel production of documents and motion for better responses from defendants Preston and Cook. So pursuant to Doc 88, that's where we're going with it, Federal Rule Civil Procedure 37 and Rule 26(1)D of the local rules.
Yep, Rule 26.
Yeah, always.
I'm so glad I have that button. I get to use it again.
Plaintiff Jeremy Hales respectfully requests the court issue an order compelling LMNOP and JC, collectively the defendants, to fulfill their discovery obligations, including by searching for and either producing or justifying the withholding of all materials in their possession, custody, or control responsive to
plaintiff's request for production, plaintiff's first set and second set of requests for production, and providing a sworn declaration regarding the preservation efforts the defendants have taken. Oh, that's a big one. You're going to have to explain what you did.
Yeah. Why you're not turning anything over at all.
All locations and data that the defendants use to communicate about relevant topics, and the searches the defendants have conducted to locate responsive documents. Plaintiff also requested that the court award attorney's fees for the costs of this motion and any additional sanctions the court deems appropriate. For nearly 137 days, both defendants have avoided fulfilling their most basic discovery obligations, including by refusing to search for and produce all responsive documents, even after the court ordered that the appropriate time to make legally proper objections is when responding to the discovery requests. It is not in response to a motion to compel or in amended responses filed after a motion to compel. Emphasis added. In good faith, plaintiff has attempted since December 2024 to resolve these discovery disputes without court intervention. While the parties were able to narrow certain issues following the January 9th 90-minute phone conference, the parties remained at an impasse regarding 1. Defendants' continued objections made in their amended responses sent January 21st, 2025. 2. Defendants' refusal to search for and produce all responsive materials despite the court's order that the defendants must produce them.
Yeah, so you got to produce them? No, we won't. Must produce responsive documents within their possession, custody, or control. That would be Doc 88. And 3, defendants' refusal to detail their efforts to preserve, collect, and search potentially responsive data and locations that may contain such materials. Both defendants have refused to state whether or not they diligently searched for and are still refusing to produce any material responses to 2 of 4 sets of RPFs or requests for productions copied with hereto 1, Exhibit 1, Exhibit 2. So the following requests for production. Defendants continue to make objections in their amended responses. 2, you got to remember, too, there's already been decisions. They're still objecting to this. Isn't this crazy? I mean, what we're being told here. So we're talking about in 1, 2, 3, 6, 7, and 9, and 17. So 1, right, it was all documents, communications relating to any allegations in this matter, including but not limited to all communications you have had with any persons or entities named in this complaint or named in plaintiff's response for, again, the summary judgment filing. God, it's going to come up a million times. Now, 2, I'm not naming all these people, okay?
Right.
This is an insane
It's
amount.
just
But
all the people related to the case.
yeah, I mean, look at how many people.
Oh my gosh.
Look at all the names. And, you know, I'm
interested in the Levy County Sheriff one. Ooh,
well, you know what's really funny about all of that is this is not narrowly tailored, and a competent attorney would have forced the scope of this because it was so broad. They would have forced you to limit that. But remember, he decided he would go in and he decided he would just throw copy paste garbage at the judge, and the judge was not thrilled about it. And Bruce is still crying about it. To this day, he is still crying about the judge making that decision.
Unbelievable.
Yeah. But a competent attorney would have knocked some of that down for sure.
Mm-hmm. What were we? Which one were you at? Did you do number 6 already?
Is that's the next page? There we.
It is?
Yeah. Lucky jumper page.
Oh, I did? Oh, yeah, I did.
Yeah,
All documents. So let's see. All
You mean
documents
three.
relating to. So number 3 was all documents relating to any statement attributed to you in the complaint or in plaintiff's responses to opposition to your motion for summary judgment, including all exhibits attached thereto, including but not limited to all documents and communications relating to any investigation into the truth or falsity of any statement attributed to you in the complaint or in the plaintiff's response in opposition to your motion for summary judgment, including all exhibits attached thereto by you or anyone else.
I love that Randy put these in. You know, you expect a little back and forth. You know, you always end up with that. And you end up with people trying to limit scope. But again, Bruce was so bad at this that you ended up with all of this just staying in place.
RFP number 6, all documents and communications of which you are aware that refute to any statement attributed to you in the complaint or in plaintiff's responses in opposition to your motion for summary judgment, including all exhibits attached thereto about plaintiff. Yeah, he totally screwed this up. I mean,
He
bad.
did. Well, he should have been able to
Remember,
go
he
in.
did boilerplate objections,
Yep.
and the judge was like, "You can't do that. You can't."
Yeah.
And he was like, "Well, why not?" And well, that's what I'm going to keep doing. Basically, he never fixed it. He never fixed it, and so it's like it's too late now. You can't complain now.
And then he talked smack to the judge. He was like, "You said you were going to give me a meeting.
Hearing.
You demanded." You know, a hearing. Yeah, a hearing.
Yeah, and then the judge just he just ignored that bad behavior. Yeah, he did. He just ignored it.
Of
Yep.
course. Well, I mean, you know, any bad behavior he's ignored. But this was an amazing failure on Bruce's part. You can look at it in 2 prongs. Like for Randy, again, you ask for everything And again, a competent lawyer will whittle that down. I mean, that's where you go. You think about that with anything, whether you go into the pawn shop, they say, I'm going to give you blah, blah, blah. And you're like, hey, I want this. And you come to a reasonable, a reasonable middle ground. Well, that's the same way in this, you get into these, deals, and he failed on the first front of it. I've rarely seen that happen. When I was watching, that's one thing that stuck with me through the Blake Lively stuff, that had been going on. You had requests for production, stuff like this. They were overly broad, and a competent lawyer came in and just chopped away at all of that. But, Randy, he's supposed to try this. That's what you do. You go for broke, and then if it works, man, but it rarely ever works. That's a sign of an incompetent lawyer on the other side.
Yeah. Oh yeah. All right. So then we have, okay, you can start at number 7.
Documents and communications sufficient to identify all usernames, handles, aliases, any other identifiers you have ever used on social media to publish information about plaintiff, name, or otherwise.
That would take me like maybe 2 hours, maybe an hour and a half to get that.
I'm curious about the number 9 though, because this is engagement letters. They haven't come off. They're arguing about the engagement letter.
Yeah, which is completely admissible. I don't know what objection they would have to that, except that he lied about it. RFP number 7, though, is a really simple discovery request.
Yeah.
Your social media handles. I have I've got Twitter, YouTube, Facebook. I think that's it.
I'm going to hit, oh my God, I hope to God that we end up going forward with the Lips lawsuit, because this right here, I would love to be able to push forward. Excuse me, which was, by the way, did I tell you about the Twitter accounts? Oh, they're Twitter accounts too. I didn't realize that.
Oh, she has Twitter accounts?
Yeah, I got one of them that has been apparently post document. I didn't even realize it.
Interesting.
Yeah. Following post.
J Decory 2012 on Rumble. I see your Rumble rant. Thanks for the 2. That says employment law is administrative law, and oftentimes it does have different structure. So it's common for administrative law, which is a specialized field of law. Yeah, that's what I understand about it. That's why I think he misses a lot of this stuff about the rules of civil procedure. I think it's different for what he practices.
I think there's some ego. It's just, if you look at other court filings that he's had, or other court cases, look at how badly some of that goes. I don't know if it's just that, or if it's there's been some really interesting accusations from people that have worked with him before. I'll leave it at that. So I mean, I don't know which one it is. Again, maybe that could explain it. Maybe, but I don't know. I mean, it's pretty freaking bad. Maybe the devil's lettuce, really. It takes your soul. All right, so let's see. 9 again. This stuff, there's nothing wrong with this. All engagement letters, invoices, documents otherwise sufficient to identify all of the attorneys with whom you have had attorney-client relationships in connection with any civil litigation to which you are a party, and or any civil or criminal litigation, grand jury testimony, and or state federal investigations relating to the plaintiff by name or otherwise. Now that would have a dual effect here. Of course, you want to be able to note everything, every lawyer that had been involved, but beyond that too, she makes claims. Yesterday, I saw a certain channel that loves to talk about Jeremy Hales talking about a protective order, and it was like, there's no protective order against Jeremy Hales. So these people that make these kind of claims, well, okay. Let's see the lawyer. Let's see something that's identified to it. Let's see some proof of this once and for all. That way you can take their words and be like, yeah, about this statement you made here, or about this statement. There's no lawyer involved. There's no court case. So what are you talking about? Anyway, Federal Rule of Civil Procedure 17. For each fact for lay witness, you expect to testify. This is basically, this is always requested. Any documents that they're going to be reviewing that are prepared by, relied upon, provided to, or received from each such witness relevant to this matter.
Why is the GPS one missing? I thought they didn't respond to that one.
It's going to the moreover. Check this underneath.
Oh,
moreover,
okay.
Defendants do not appear to have ever engaged in a collection, professional or otherwise, of all potential sources of responsive information to the following requests. That would be 5, 8, 10, 11, 12, 13, 18, 19, and 20.
Oh,
so they've
boy.
never done anything with those at all. Yeah, that's wild. Defendants have not confirmed whether they have ever searched any of their own social media / email accounts or engaged in any search of any of their text messages or messaging applications. So they didn't turn over any social media messages, even though we've seen that stuff, any email account information, any text messages, according to this, or any other messaging applications.
Mm-hmm.
That's wild, especially considering the just sheer volume of stuff that we've seen. So the defendant's responses to, we're going to say 4, that would be all documents and communications concerning the steps you have taken to preserve documents and communications relevant to the lawsuit. Listen to this right here. This is their response to this, including documents and communications responsive to that, is that there are no... Scroll down.
Oh, sorry. I was behind.
No, you're good. There are no
responsive documents.
Yeah,
Okay.
so my answer there is, yep, there's nothing. But they don't provide anything saying that.
They're like, I searched, this is how I searched, and this is what came up. And
They're saying there's no email. I mean, they're going with, oh my God.
Exhibit 1-2, as stated in plaintiff's first motion to compel discovery document 52, defendant's discovery responses stated that each defendant will only produce at some unstated date the text that each defendant still saved. See discovery responses to RFP 1, 2, 3, and 6. This is very convenient. So if the defendant says, I didn't save it, it's gone. In their amended responses to the same request, defendants again lodged objections to RFP 1, 3, and 6 and produced nothing in RFP 2, see Exhibit 5 and Exhibit 6. This means defendants' decision to opt out of meaningfully participating in the discovery process violates the federal rules, this court's order dated February 26, and necessitates the court entering the relief plaintiff respectfully requests herein. Since the court's order dated February 26, instructing defendants that they may not object to any amended discovery responses, defendants still maintain the objections to their amended discovery responses and have produced nothing, despite being advised that if defendants have responsive documents within their possession, custody, or control, then they should provide as such to plaintiff.
So they're refusing again to turn over anything. So the judge is like, hey, you can't do that. You can't object. Well, we object anyway.
We object anyway. Well, yeah, and he'll probably let them get away with it, too. On March 20th, 2025, plaintiff sent defendant's counsel a deficiency letter, which specifies even further defendant's deficient responses, a copy being attached here to is Exhibit 7.
That's what he threw a fit about. Remember the deficiency letter? He was saying, hey, I'm going to send a deficiency letter.
Mm-hmm.
So, yeah, too. As of today, there have been no further responses. What was the date on that, did you say?
That was March 20th.
So since March 20th, there have been no further responses.
Mm-hmm.
That's wild, isn't it? And defendants refuse to engage in any diligent search, despite plaintiffs seeking this information since November the 12th, 2024. So we are talking about, right on 8 months. Defendants have never provided plaintiff or the court with an explanation of the steps, if any, taken to preserve responsive materials or to search the full universe of records. I like that. The full universe of records potentially responsive to plaintiffs' requests with their possession, custody, or control. There's not even been a response to plaintiff's first deficiency letter. So plaintiff served second set request for productions. That would be second or FPs, and that would be in February. So in late February, that'd be February 24th. As of today, nothing has been produced. There has been no response by defendants to the second request for production. Exhibit 8, Exhibit 9. Accordingly, March 27, 2025, plaintiffs sent defendants a second deficiency letter, which is
oh boy.
It's wild, isn't it? This stuff is crazy. So, memorandum of law. Federal Civil Procedure 37E provides for certain forms of relief when a party fails to take responsible steps to preserve electronically stored information that should have been preserved in anticipation or conduct of litigation. Under the federal rules, the presumption is that the responding party must bear the expense of complying with discovery requests, including when discovery is stored electronically.
When a party fails to obey a discovery order, the Rule 37B authorizes the court to issue further just orders, including the imposition of sanctions, such as directing that the matters embraced in the order or other designated facts be taken as established for purposes of the action, prohibiting the disobedient party from supporting or opposing designated claims or defenses, or from introducing designated matters and evidence, or treating as contempt of court the failure to obey.
Hey, while we're reading this, remember the judge, as part of this, just to know, this would have been decision 153, noted that the defendants will have an opportunity to respond, so they have until the 26th to actually respond to this. Why they haven't turned over Jack nor Shite.
Jack nor Shite.
Yeah.
I would love that to make it into a filing. The defendants have turned over neither Jack nor Shite.
The law offices of Jack nor Shite have not responded to us.
Oh my gosh. So failure to obey an order. Rule 37B provides comprehensively for sanctions for failure to obey discovery orders. When a court grants a motion to compel, the court must, after giving an opportunity to be heard, require the party or deponent whose conduct necessitated the motion, the party or attorney advising that conduct, or both, to pay the movant's reasonable expenses incurred in making the motion, including attorney's fees, unless certain circumstances exist. And there's a footnote. The circumstances are that 1, the movant filed the motion before attempting in good faith to obtain the disclosure or discovery without court action. 2, the opposing party's non-disclosure response or objection was substantially justified. Or 3, other circumstances make an award of expenses unjust. The judge will probably use that one to say, well, they're indigent. So
they're indigent, so they don't have to follow any rules that I set forward.
Right.
Most judges have a spine, and after a while, when somebody flips them to the freaking bird, they are questioning his judicial authority. Like, that's what all of this has been about. I mean, they have gone out and made a mockery of this court.
They have.
That's
and he's
crazy.
allowed it. It's his fault.
Yep. So Rule 26C, which
Hey, Rule 26, one more time.
states that once a party has responded to a request for production, it must supplement its disclosure in a timely manner if the party learns that in some material respect the disclosure response is incomplete or incorrect, and if the additional corrective information has not otherwise been made known to other parties during the discovery process. Now, the federal rule does not. Which rule is that? Oh, 26.
Hey, Rule 26, one more time.
You might as well keep it handy. It's going to come up
That's
again.
handy. Don't worry. I've got my finger hovering over the button.
Does not sanction late disclosure for late disclosure's sake, nor is it a license to sandbag the opposing party with reams of pertinent information on the eve of summary judgment. Yes, that's true too. You can't, like, on the eve of it be like, oh, by the way, smash,
Here's the discovery. Yeah.
Simply stated, Rule 26E
Hey, Rule 26 one more time, motherfucker.
is not, nor has it ever been, carte blanche to ignore court or impose deadlines. Yet, with the discovery deadline just 3 days away, the defendant's delays seem calculated to sandbag plaintiff in hopes there will be no extensions, especially to those regarding summary judgment. The court should compel defendants to review each of the plaintiff's document requests. Number 2, perform a complete and thorough search for responsive documents, including social media, emails, faxes. 3, to provide responsive documents to plaintiff. 4, upon completion of discovery, to certify to the court that they have responded fully to all document requests. There are no other responsive documents exist as the time of certification.
Argument. The court should compel defendants to detail their preservation efforts to date. To date, defendants personally or via counsel have not articulated any specific steps that they have made to preserve what they know or reasonably should know, what is relevant in the action, what is reasonably calculated to lead to the discovery of admissible evidence, what is reasonably likely to be requested during discovery, and or what is the subject of a pending discovery request. And that's Rule 37E. Rule 26
Hey, Rule 26 one more time, motherfucker.
imposes implicit duty to preserve relevant documents and records. A district court has broad discretion in managing discovery and handling disputes. And that's an 11th Circuit ruling. Here, defendants' responses are completely inadequate. This is because defendants' responses to plaintiff's document requests have been incomplete, and its objections to production are now waived. Yep. Defendants
I think incomplete
refuse.
is a very nice way of putting it when you don't turn over anything.
Yeah, that is a nice way of putting it.
Yeah.
Defendants refuse to engage in a search for or produce any materials responsive to the first set of RFPs. Defendants must, but have failed to, search for or produce all records in their possession, custody, or control, which the law defines as those one has the right, authority, or practical ability to obtain. The 11th Circuit has held that for the purposes of Rule 34, control is... What is control, Tug?
It's defined not only as possession, but as the legal right to obtain the documents requested upon demand. Now, other cases in this district involving sibling companies extend control to include situations where a litigant has the practical ability to obtain materials. You have a case here. Notes, quote, control does not require that a party have legal ownership or actual physical possession of the documented issue, but merely requires that the plaintiff have the right, authority, or practical ability to obtain the materials sought on demand. Now
that would explain like the GPS thing.
Yes,
like
that would also
you
explain
have the authority to contact your car dealer, the car dealer where you bought the car, and contact Jeep and say, I need to access my GPS data on the car for court.
Well, again, they're not turning over phone records or anything. Okay, well, they're not even turning over, it sounds like, the way I'm reading this, they're not even turning over anything that discloses what phone numbers they've had, Because she was talking about having multiple. See, if it turns out that they didn't have multiple ones, if that's a lie, then all the disclosure with new phones, new this, they should have been able to keep their stuff anyway. Because when you transfer data from one phone to the other, keep it. There's no reason that she shouldn't have most of this stuff anyway. It's ridiculous. So inter alia, as far as the GPS records, that would be 13. Phone records, 5. Mobile phone records, 12. Defendant merely responds. There are no responsive documents in the defendant's possession, custody, or control. So Their answer to phone records, again, the numbers that are utilized, period. They're like, we don't have anything. That is insane to think. But without acknowledging their legal right to obtain the documents requested upon demand from vendors, 2, apparently without searching for the responsive documents available from the provider itself. Number 3, without providing any basis for the refusal to produce materials to which they have actual practical access. Nor have defendants, nor can they claim that obtain these records would constitute any burden. Yeah, there wouldn't be any burden. Just contact them and be like, yo, I need to get this stuff. Plaintiff does not need to perform defendant's discovery duties to obtain responsive information that is reasonably accessible to them. Again, what federal rule?
What rule?
Hey, rule 26, one more time, motherfucker.
Defendants should not be exempt from the discovery obligations of
searching for and producing all materials in their possession, custody, or control is defined by the 11th Circuit. Defendants should therefore be ordered to provide the court with a declaration that details all efforts used to communicate about any materials responsive to any of plaintiff's RFPs, including but not limited to specific email accounts, text messages, messaging applications, social media devices, hardware, and any form of communication, and what searches, if any, have occurred. What, if any? The court should compel defendants to respond to plaintiff's second set of RFPs and grant plaintiff additional relief and sanction defendants. Plaintiff filed this motion only after 1, attempting in good faith to obtain the disclosure or discovery without court action, 2, sending out 2 deficiency letters, and 3, participating in a 90-minute discovery phone conference, all of which provided defendants additional opportunity to cure deficiencies. Yet since being served with plaintiff's first set of RFPs, defendants have been unwavering in their resistance to participating in even the most basic discovery and must pay for plaintiff's efforts to compel defendants' participation. The court should preclude defendants from relying on any evidence not provided in their initial disclosures. The court should preclude defendants from relying on witnesses or information not provided in their initial disclosures. And see this rule 37 that says, and Tug, you can pick that up, if
a party fails to provide information or identify a witness as required by rule, what?
Oh, rule. Ah.
Hey, rule 26, one more time.
Lay down on the job there, my goodness.
I know, I'm falling down.
A or E. The party is not allowed to use that information or witness to supply evidence on a motion at a hearing, trial, unless the failure was substantially justified or is harmless. So, I mean, that's a big deal right there. If they're not going to turn this shit over, then they can't use it as part of their defense.
Nope.
You know, I mean, that runs them right into a wall. This means defendants should not be allowed to testify about conversations.
Does that also mean that they won't be able to use any of their alleged hate messages? Because they didn't turn anything over. So, like, they're saying that they got all these Jeremy Hale supporters sending them threats and stuff. Like, well, you didn't turn it over, so you don't get to use it.
Yeah, I mean, well, and that makes sense because you have no time to authenticate. Like it's also saying that if they were planning on the eve of this coming to fruition, like that, I can't remember what the date was on it. It's past now, the discovery date, but they've been given a chance to respond, even though the date's passed. Good job, Judge, by the way. Good job sticking with those deadlines you said are just firmly set in stone.
Yeah, exactly.
Oh my God. But what a mess. Anyway, I'm going to rant if I fucking
How much you want to bet that the next move that Lynette and John are going to play is we need an extension for discovery?
I expected that, to be honest.
But they won't file it until the 26th.
Yeah.
They will file it on the 26th.
If we file it on the 27th.
Yeah, they might even file it the next day. And if they do, and how much you want to bet that the judge will give it to him?
I mean, that's kind of been the way things have gone so far, right?
I mean, there just is no justice. It's this delayed justice is no justice at all. I don't know who said that, but I know that's a real thing. But when you have delayed justice like this, no one is getting justice. It's just constant delay.
This is not how it's supposed to be, by the way. This is not how things are supposed to work at all. When people watch this and they think, oh my God, the court system is slow, for sure. They are slow. They run at the speed of, how much money they can bleed from you. But at the same time, it is not supposed to be like this. When you set deadlines, you're not supposed to. Every deadline they have set it's been overextended. And even when that's happened, the judge has been like, sure, no problem. Now, imagine if Randy would have done that. I imagine that judge would have been really quick to step on him.
Oh, yeah. He absolutely would. He probably would have sanctioned him, too. Unbelievable.
Okay, so this means the defendant should not be allowed to testify about conversations which occurred with anyone whom they do not list in their initial disclosures. That's true, by the way. They should not. If it didn't exist before, you can't just magically make it appear later. So the court should impose additional sanctions as it deemed appropriate because defendant's conduct or lack thereof during discovery has prejudiced plaintiff. So plaintiff has incurred significant time and expense. That is indeed true. Conferring with defendant's counsel, including lengthy deficiency letter over the course of the last few months. Yeah, it said since November they've been trying this. In response, defendants have delayed, obfuscated every turn, so much so that the defendants were essentially given until March the 4th. Wow, March the 4th. Where are we now? To respond to the first set of RPFs, which were served November. That's right. So in other words, something which should have been produced in December 2024, not 2025, by the way. It's a typo.
Oh, it's a typo.
Yeah. Another typo. What's funny is people like BBB, they want to go grammar Yahtzee. And yet when you look at some of their stuff, you're like, oh my God, was not ultimately produced until March 4th, 2025, due to the defendant's many delays, requests for quote-unquote clarification, which included a motion for reconsideration, which was denied. This court's order granting the plaintiff's first motion to compel production of first set of RFPs. The first deficiency letter followed thereafter. Plaintiff does not wish to depose defendants without having complied with discovery. That's true. You want to see what's there. You're going to see what they rely on. Essentially, okay, it's all locked down because in the aftermath, they can't be like, oh, well, look what we found. This isn't Perry fucking Mason. Or Better Call Saul.
That would be unfair surprise. You can't do that.
Because responsive materials must exist and must be produced. Now, for their conduct,
the plaintiff respectfully submits that the court should exercise its inherent power and broad discretion to order contempt citations, fines, awards of attorney's fees, and such other orders and sanctions it finds necessary to assess against defendants. For example, plaintiff respectfully suggests, while deferring to the court's discretion of what sanctions are appropriate, that the court could preclude defendants from relying on any document or any testimony relevant to such document the plaintiff has requested, but which they do not produce. Precluding a offending party from relying on documents requested but untimely produced in litigation is quoting more case law. Recently, in an attempt of filing a motion for summary judgment during the recent stay of this case, documents were attached which were never produced by defendants and are responsive to plaintiff's discovery requests. Oh my. Oh boy, which ones were those? Do we know which documents those were? He doesn't say which motion for summary judgment, so I guess it's anybody's guess because I feel like there were multiple. Yeah. Accordingly, plaintiff requests an extension of the discovery deadline of 45 days after these responses have been
I know which one
made.
that is. That's the one that John Cook filed. Remember the one that Bruce threw a fit about because it was supposed to be his end game, and John Cook just dropped it out there. It had the communications with whatnot that we had never seen before.
Oh, right.
Yeah.
Oh
So
my gosh.
yeah, they entered stuff in as evidence, but they will not turn it over as evidence. I mean, that's crazy when you think about it. I mean, they're admitting they have this stuff. When they were bragging about their in game and all of that, they should have turned that stuff over. Those communications 100% are supposed to be turned over.
Wow.
And they did not.
Accordingly, plaintiff requests an extension of the discovery deadline of 45 days after these responses have been made. Wait, so Jeremy's requesting an extension of discovery deadline to allow for the deposition of defendants and expert witness discovery. But he just said he didn't want to do discovery until, didn't want to do depositions until discovery was handed over. So I guess they're asking the judge to give them 45 more days to turn stuff in? I wouldn't. Maybe I'm reading that wrong.
I don't know. What was that again? I had a writer for a second.
Oh, well, this says, accordingly, plaintiff requests an extension of the discovery deadline of 45 days after these responses have been made to allow for the deposition of the defendants. Oh, I see.
Yeah,
after they give us the responses. Yeah. So if they give us these responses by the time they're due, we need 45 more days to go through it all. So that we can then depose people properly.
Yeah, because if they're going to turn over anything, again, you're not allowed to just do any kind of dump. But he's making sure that if they decide they're going to dump some kind of documents on the eve of it, that they have time to prepare for it. That way, you're not you don't miss something.
Right. All right. Conclusion: for the reasons set forth above, plaintiff respectfully requests the court grant the plaintiff's motion and compel defendants to collect, search, and produce all materials responsive to all of plaintiff's RFPs, specifically detailing the searches defendants performed specifically for materials responsive to plaintiff's RFPs within 15 days of the court's order, and bear all related costs. You can pick up to.
1 second here. I was trying to figure out. I've been looking at the lips filings, and I was like, how in the hell am I supposed to organize this mess?
Oh God, I know.
Man, there has been so much stuff, so much damning information, by the way. Her taunting people, it's crazy. Like, I can't believe the amount of stuff that I've been putting away. That's what I've been doing, when we talk. I've been trying to, I got everything nice and neat, filed away where it belongs. And then she pops up and it's like, holy crap, man. How much stuff has she produced just in what's she been around a month, maybe? If that, a month, would you say?
I guess.
I mean, if that, well, in that time, she has had, God, almost are over 20 alt accounts. There's at least like right on a dozen known YouTube channels. How many websites? Oh my God, hundreds of videos, posts. She's created more in that month than everybody else combined during this entire trial so far. Already. Yeah. And I'm documenting the shit out of it because, again, it's crazy piece of shit wants to bring a lawsuit, so of course you want to document everything. Oh, anyway. So if that she needs to they need the extension. They need to compel defendants to file a declaration subject to penalty of perjury, requiring defendants to detail to the court within 5 days of the court order all efforts to preserve, collect, search potentially responsive documents and data, a complete list of all locations and data that defendants use to communicate about any materials responsive to the request for production, including but not limited to vendors, specific email accounts, text messages, blah, 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 blah. We've already read that. Preclude defendants from relying on evidence not provided in their initial disclosures. Preclude defendants from relying on any document or any testimony relevant to such document that plaintiff has requested, but which they do not produce and or have not produced to date. award plaintiff costs incurred for the filing of the motion, subject to future filing detailing the same, and extend the discovery deadline 45 days after the response compelled by this order have been allowed to allow for the deposition again of defendants, expert witness discovery,
and order any additional forms of relief so desired by the court, including those discussed herein. Plaintiffs request oral argument should the court have any remaining questions not addressed by the briefing. And then there's the good faith certification. Now, what date this was filed?
Wait. Look at the just let's see if what it says in the good. You know how some of them are crazy. Let's just make sure it reads normally.
All right. Pursuant to the local rule, counsel for plaintiff
so
conferred with
we're
defendant
unable.
Preston.
Yeah, it's just you know how some of them with Bruce are like crazy. I've gotten to the point where I read all the good faith.
Well, he's just saying that they complied with the correspondence.
They tried
rule.
and it failed.
Yeah.
But some of them are just wild. In this case, I've never read those really. You know, they're just usually it's there. Of course, it's required, but it's part of the process. It's saying, hey, we communicated. And with Bruce, especially with his filing, some of those get just crazy. I've never seen some of it.
This was filed on the 13th.
Mm-hmm. And then there was an order about it.
There was?
Mm-hmm.
Oh, okay, great. I want that. So that was 152. So here's 153 is the order. I got that. Let me pull that up.
It's pretty basic too. It's like it gives them time to respond. So they have until the 26th to respond.
But that's also the deadline for discovery. So
yeah, so I mean, they're going to have to extend discovery. There's no way that he cannot extend. Again, if he doesn't do that and they come off of nothing whatsoever, and he doesn't allow for something for Hales where they come off, I mean, nothing. They're just like, hey, we don't have anything, and you know it exists. Shit, she's still posting on some of this, and not just that. They brought in other cases. So I started thinking about this after this was filed. Ohio, the stuff that she's brought in her defense, those things should be turned over. Everything that's related should be turned over. She's returned over nothing. And that includes with Ohio. It's all on record what she tried to rely on, including her talking about standing in the truth.
Mm-hmm.
I mean... What? I mean,
and she's still posting about it right now under that Otter Creek Pickles whatever thing, and she's not including any of those either. It's like, well, we have them. You're doing it. We know you're using social media. Why haven't you turned this over?
Well, she's deleting too. So just to note this, she posted on the Pickles one. She posted all of this conversation the other day. You know, including responses and more. She's ghosted all of this. All of this is gone. Now, I did archive it. I still have it parked here so you can see it, you know, everything that took place on that too. And right now, which I think we'll go over this tomorrow because somebody made a good counterpoint to a lot of this stuff here. She posted a good look at the size of this post here. Look at this.
It's huge.
Yeah, look at it. It's going. It's still going.
Oh, wait, I don't have it up. Hold on.
You don't have it?
Okay, there we go. Oh, my Lord.
Look, check this out. So, look at all this. Look at that. That doesn't even count the responses.
That's what you call a wall of text.
Mm-hmm. Now, I made sure to document that. I'm sure that Hales probably documents everything as well, but it's not on him to document this. That's the kicker to all of this. People need to understand. It is not on him. They're supposed to turn this shit over.
And I guess we'll find out what happens on the 26th. So
yeah,
that's Thursday?
Yeah.
Okay. Well, then that's it for us tonight. I'm going to hit the super chats. And are you sticking around, or do you need to go supervise Potato Factory happenings?
For a minute. You know, I'm screenshotting something, so I'll stick for a minute.
All right, cool. All right, where did we leave off? Let's see. I think we left off with Jackie Hampson, thanks for the £5. Hey, Megan, here's some breadstick money. Loving the channel. Well, I'm so glad that you are and that you're here. Willie Borzash, thanks for the Canadian 10. Celebration breadstick time. Thank you very much. Janice Wingfield, thanks for the 10. Does Lynette have a new attorney yet? Nope. Susan Way, thanks for the 2. Laughing at the idiocy. Love your Muppet, by the way. That is very funny. Just J Hip, thanks for the 5. How many bucks of dollars will I get? You mean for your
lawyer? Don't give away our strategy here.
Right.
God, my lawyer always giving away the strategy.
Be the bland one, thanks for the 5. As a fellow New Yorker, I'm aware we're all fast talkers. I think you've had way too much caffeine today. I don't think Tug's ears can handle such speed. Well, we just had a lot of material to get through, and I wanted to get through.
I thought we did pretty good today.
We did. We got through 2 documents, and one was 17 pages. You know, that might be a record for us.
It was amazing, to be honest.
Joyce Burnt, thanks for the 2. Can Lynette spell stupid? Not sure. Doubtful, though. Joyce Burnt, thanks for the
stupid.
Bruce. Joyce Burnt.
He had a post today, by the way. That was just, oh God, if people have not seen the
Who,
community
Bruce
post.
Did? Or
no,
Dave?
No, Dave. Oh, my Lord.
Oh, I
so
did
funny.
see it. It's absurd.
It's so butthurt, whining about the Whopper thing really got to.
I know. I fell asleep reading it. That's how boring it was. I thought it was terribly boring.
Well, he was trying to steal Shizzy's. 2 of them have tried that now. They've tried to steal Shizzy's.
Yeah, but they failed miserably because they're supposed to be funny and zingy, but theirs was so boring. I fell asleep.
I don't know. They zinged me like melatonin. It was pretty amazing.
Zinged me. I fell into a deep sleep. Joyce Burnt, thanks for the 2. Mrs. Fox, locked and loaded. And David E. Jones, thanks for the 5. These people don't even know how to engage sport mode on their urban pink camo Crocs. Becky Furek, thanks for the 2. Mic drop. Yeah, I personally think the checkmate scenario is unbelievable. It is a mic drop moment. John Alive, thanks for the 2. Could this be the fabled royal flush coming true? Jack Smog, thanks for the 5. Under this, wouldn't lip suit be the 3rd one? So automatic dismissal and sanctions. So it would be not yet. She filed it once. She dropped it against us. Then she refiled it with us. So that's one time. If she dismisses again or she doesn't serve us, then yes, automatic for the 3rd. If she tries it a 3rd time, it's a can't do. Yeah. No can do.
We hit it, too. I'm telling you, like there are a few things that I feel confident enough to say that's a slam dunk for us. But again, she has lied in her filings. I mean, 100% falsity with timelines and more. She's omitted to the point that it's an easy anti-slap, but I don't know if I want an anti-slap. I really kind of want some of the material that's attached to her.
Yeah, but unfortunately, that would be a mistake because all she does is paper cases.
Yeah.
And it would be unbelievable delays. It would be... I know you want to argue the facts because, she doesn't have the facts on her side. But I think it would be a mistake because of the way she litigates.
And hitting her with the lawyer costs would actually be pretty funny too, because it's automatic hits.
Yep, it is. So Terry, American Woman Thrifter, thanks to the 5. When is BBB going to get sanctions from Judge Blythe, though? Who the hell knows, Terry? It doesn't look like he's going to get them at this point, which is really unfair to Randy, who had to pay $4,000 in sanctions when he was the one who showed up.
Yeah, the only person that showed up.
And the judge sure talked a big game about being so upset that Bruce, violated the court order and didn't show up, and how he's going to have a big order and it's sitting on his desk and it's just waiting. Well, what are you waiting for? What is he waiting for? I don't know. But it appears that he's either forgotten about it or he doesn't care. Knock it off, Lord. Thanks. Yeah, thanks for the 2. I waited all week to show Megan my avatar. IEYE. Flurfs. I love it.
Yeah.
I love it. M-Spire member for 8 months. You can't fix stupid. Let's see what bullshit they do next. Well, you can be assured it will be some bullshit. Bunsen Rockenstone. I love this name. And the Muppet Avatar. Please never lose that. It's so great. Member for 7 months. 7 months of chaos. Wow. Yes, total chaos. But it's fun, isn't it? Nana Misty, thanks for the 2. Fantastic Muppets, by the way. More like dumpster diving. Sweet baby dumpster Jesus. Maybe we need to pray to sweet baby dumpster Jesus to make all of this stop. Dwayne Norvell, thanks for the 2. But Lynette is weaning. Yes, she's winning. She's winning. Starchasm, thanks for being a member. I'm sorry, who wants to hear more Jay whining?
Do not insult my lawyer. Come on now, Starcast.
Aussie Roo, Jesus or Jesus, thanks for the Aussie too. Hi, Megan, Tug Breadsticks. I love your kangaroo Muppet, by the way. AKA the cat lady, thanks for the 5. I got locked into the Harold Washington Library when I was 8 with my mom. I was terrified. We had to find a phone and call for help. That place is huge. That would be kind of amazing. That would be like getting locked in a museum overnight. Could you go like from floor to floor? I bet you could, because they have stairs. They have 8 floors in that sucker, and it is ginormous.
Man, I bet that place would be crazy and scary.
And scary at night. Yeah, they even have like museum floors where there's like stuff to look at behind glass. And
this is crazy. So I went to Gatlinburg one time. They have an aquarium up there. Awesome aquarium, by the way. Great place. But I went up there and I was just wandering through. I like to go late at night because there's less of a crowd, right?
Sure.
Well, around closing time, I noticed. I was like, well, I'm going to go until they tell me I have to leave, right? I mean, that's fair. Well, I noticed the time went past. And then 20 minutes went past. It was like, they're not kicking me out. What's going on? Apparently, there was a sleep-in. This tells you how terrible the security there. They had a school sleep-in, and they assumed that I was with the school group for some reason.
Oh, no.
Yeah, so I stayed down there. I stayed down there like an hour and a half looking around. It was empty. It was amazing, because the wherever the group was, they were off in some corner, but they have like one of those tubes you can walk through, sharks all around you.
Cool.
Yeah, and I got to sit down there. I just stopped and sat down and was like chilling. I ate a sandwich down there.
Oh, that's so cool.
Yeah, but they assumed they had locked me in. They locked me in with the group, and I was like, at the time I have really long hair, like long facial hair. I was like, I do not look like you. You should not assume that I'm with this kid group. That's kind of strange.
That's funny.
Yeah,
I've always wanted to get locked in a museum overnight. It
was amazing. I was
be
thrilled.
fun.
And since they did it, they were so embarrassed by it that they allowed me to stay another hour, and all the stuff that the kids group did, since they had all these people there to show them the like, stingrays and stuff, they just did it for me. So, all by myself. I were like, oh yeah, you want to pet it? Like, hell yeah, I want to pet one.
Hell yeah. Yeah.
You want to see this shark do blah blah blah? Hell yeah, I want to see that shark.
Oh, that's funny.
Yeah, it was amazing. It was like I had my own freaking aquarium for that like hour plus.
I love that. Kim Boyko, thanks for the 5. Have a drink with me. You can use and then it got cut off. But yes, I love your Muppet avatar. Check out she's sitting at a bar with a tropical drink. I love it. Wheezy Wheels, member for 11 months. You guys rock. Thank you for everything you do. Well, thank you for you guys being here. Without you, we wouldn't have a show. TST gifted 10 Megan Fox memberships. TST, you are awesome. By the way, I don't know if you were here the other night when I thanked you for your $50 super chat on the Hernandez case live stream. It came in just as my stream was ending, or as I hit the end button, and so I couldn't say hello, thank you, but I got your super tip and I appreciate it. Love your Muppet, by the way. I love it. DeFloofy Cat, member for 1 month. The overlords are enjoying the cat and mouse chase of this case, or is it Fox and Chicken? One never knows.
I love DeFloofy. The kids love DeFloofy Cat.
I love the Muppet too. It's great. Shifter Brains, thanks for the 20. Elemental P being deemed indigent. All motions, etc., are omitted free of charge, with BBB papering the court, causing Jeremy massive money to respond. If proved she's not indigent, will she have to pay court for all motions? I don't know. I don't even know if that's even on the table. Like, nobody's asked for it. As far as I know, Jeremy's lawyer has not asked for proof that she's indigent. He's mentioned it in filings that he doesn't believe she is. But I think it has to be, you have to ask the court to investigate it. And by the way, look at how we have DeFloofy Cat here in that one. And then we have Shifter Brains. We got the dog Muppet. We get the cats
funny.
and the dogs involved.
Oh my God. It's gotten to the point the cats and the dogs agree.
Jack Miles, thanks for the 2. Her time ends on Thursday, June 26th. Yeah, I'll see it. I'll believe it when I see it.
Yep.
Lizard King FL, thanks for the 5. No one has stepped up to say, hold my beer. Tug hasn't said it can't get crazier either. Coincidence? I don't think so. No, it can get crazier, and we're all very aware of that. This case never disappoints.
It really can. You wouldn't think that it could, though. You really wouldn't. You wouldn't think after everything.
Oh, but I know
going
it
on.
can. I
Oh
know
my
it's going to
God.
get even. It's going to get even weirder. I mean, no doubt about it. Just
Yeah,
no
well, I'm
doubt.
wondering who the next recruit for the ecosystem is going to be, or
Who's going to be the next one to step out of the clown car? Like maybe they'll get an actual like axe murderer this time.
You can't. There's not much more room to go and to make it any weirder.
We've got
I mean,
felons,
good Lord.
disbarred attorneys, Botox queens. The only thing we're missing is like a serial killer. Oh, a harasser for hire. We've got it all.
Oh, that
we need
that case is almost to the 30 days as well. That had 30-day decision for. What's his face? I can't think of his name.
Dinesh.
Yeah.
So, that judge hasn't
30
ruled
days,
in that one yet.
Yeah. I mean, well.
What is with these
With that,
judges?
they also have come off. In that case, it's interesting to read because, some people are like, man, he's this or that. Well, I don't know anything about the guy. What I do know is they have this overlap here. And when you read through it, there are a lot of similarities. Like, for example, they have never produced anything as far as discovery is concerned. The parties that he's going against, no discovery, nothing. So you're looking at the same thing.
But Dinesh provided discovery, and then they used his discovery to give it to Paint Chips, who then disclosed his private medical information.
And they admitted it. That's the crazy. They admitted it. So you have it documented that Paint Chips is a verified harasser. I mean, you could go back to that. I would recommend doing that. In fact, I think that would be something that maybe a lawyer might want to look into.
Marnie, thanks for the Canadian 7. I bet Lynette's new lawyer is Attorney Worm, ex Otter Creek lawyer. I don't think so. I think Worm already said no. I think he already
remember
said
they
no.
tried all of those Otter Creek.
Yeah, they tried him.
Yeah, from the documentation. That's the way I understood it before, anyway.
He said no because it was too far. Pensacola.
I also don't think, I think a lot of people see BBB and the way that he's comported himself. They've had to deal with him, and they're like, oh. Now he blames that on Hales. He's always like, oh, it's because of Jeremy, but really,
or it's because of our coverage. No, sir, it's because of your behavior.
Yeah, it's because you
good
act like
attorneys
a jackass.
don't want anything to do with you. No, good attorneys who behave themselves and who follow the rules, they don't want anything to do with you. And you've made this case toxic. It's not us. You did that to your own reputation by the way you behave. BC Eagle Deb, member for 5 months. Please wish me a happy birthday, Megan. Happy birthday. Uh-oh. That's what we got to sing.
Oh, my God. Is it your birthday?
We have to sing.
Okay. Are we ready?
Am
I doing the claps? I'm going to bring more claps than
You're just going to sing. You can do the clapping and the singing, and I'll just I'll add my own spice.
It's going to be like a Mexican free healthcare clinic. I'm going to have so much clap here. Here we go. Wait, what's happening?
I'm waiting.
I'm waiting for the song. I'm waiting for the music. I don't have anything to clap to.
No, you have to do both. I said I would add my own special spice
What?
to it.
I'm
Yes, you have to do
singing
both.
too? My
Yeah, you're
God.
singing too.
My Lord. I mean, what else? Here, let me bring up I need my perfect avatar for this, by the way, since we're going to do that. Let me, I'll just bring up the picture, so you can see it all.
Okay.
Here. Yes, let's.
Oh, perfect. All right, here we go.
Yep, there we go. Isn't that beautiful? Look, battle damage. Look what I had to do to get here to sing this to you. Battle damage. Okay, so here we go. Happy birthday from all of us to you. Megan isn't singing, but that's okay because we still love you.
Woohoo! Happy birthday.
Whoa, man.
That's my-
Don't hurt yourself with all that celebration, Megan.
April Keys, thanks for the 2. Order on June 12th, gives until the 26th. Thank you for that. Tracy Wilden gifted 5 Megan Fox membership. Welcome to the Fox Den. It's weird in here. There's some awkward singing. And
oh my God, I have so much fun with that shit.
and we are not sorry at all. Just J Hip, thanks for the 5. I won't be disposed by myself. There will need to be an adult in the room on my behalf. Yes, that's true. You do need a guardian. Debbie Baker, thanks for the 10. Megan, please don't make Jay cry. I love Jay and he wants to be a lawyer. He will be great as long as Star is in the room. Oh boy.
Indeed, as long
I
as
don't
there's
know
somebody
about
else.
that. I feel very nervous. William Allen,
Hey,
thanks for
it can't be worse than some of the people we've seen.
That's also true. I did say when you were gone earlier, I may reconsider my position on letting Jay be my fake lawyer in this fake lawsuit. Since, I haven't been served or anything.
Exactly.
And so I don't see what it could hurt for him to be my fake lawyer for the fake lawsuit. William
Exactly.
Allen, thanks for the 10. A joke I saw in chat. What is Legally Liv's favorite flower? Tulips, of course. That's funny. Sassy Mama C, thanks for the 5. Tug and Meg, I have a bunch of stuff to send you. Hurry up and get a P.O. box. Also, Jeremy has mail for you, Megan. Love you guys. Yes, I will be doing that soon. Give me another week or 2. I'm working out some stuff. Rusty Ray Hips, thanks for the 2. Paying the troll toll for Okimima. Awesome. I'll take your troll toll. And Wanda Perez, thanks for the 5. Love you both. Have a good night. Well, you too. And Tess Campbell gifted 5 Megan Fox memberships. Welcome to the Fox Den, all of you. You're in now. You can't get out. Don't even try. And we are, let's see, I made it through the super chats. Let me check over on the Rumble rants. It looks like we are caught up there. And I need to check super tips. I think there's 1 or 2. Let me see. Where's super tips? Super tips. By the way, if you want to try out super tips, those are a lot of fun. Super tips it is supertip.gg/Megan Fox, and you can send a super tip with somebody else's voice used on created by a computer for satire and parody purposes only. Thank you, SF, for the 5.
Rule 26.
That was supposed to be
Instead of it with
was funny too, though. And let me check and make sure I didn't miss any Cash Apps or Venmos because we did put that on the screen earlier, and make sure I got it all. Looks like dun 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 dun. No, we are good. We are all caught up. All right, you guys go over and see Shizzy. We are going to do a Shizzy raid right now. Go over, tell Shizzy we said hello, and Tug will be back tomorrow night. I will be with him, and he's going to be going over. What are you going over tomorrow night?
Oh, I don't know. We have some of this crazy stuff that has been on the posting sprees. There's a lot. Let's just say there's a lot. I just got to figure out exactly what part to go over.
All right. Well, excellent. Thanks for being here tonight, guys, and for all the support that you give our show and all the fun that you contribute to the conversation. We'll see ya.